for judgment. Item number 1, WA 337 of 2019. The appeal is dismissed.
May I be pardoned?
Mention.
May I pardon, my lord?
May that the order dated 30/5 passed by the Honorable Single Judge in petition number 6843 of 2005 is under challenge.
How is this writ appeal maintainable?
The writ appeal is maintainable only because the writ petition was only under Article 226 of the Constitution, and certain hidence is played that he has not disclosed the matters which were disposed earlier by this court on several occasions.
What is wrong on merits? Tell us about merits now.
And finally, the merit is a trespasser to the suit land. And the suit was decreed by the Court of Civil Judge, Junior Division, Bhadrak, that is Munshi, on dated on dated 7/1/85. Thereafter, he came before this first appeal before ADJ Bhadrak 14/1985, and which was disposed of on 4/4/89. Thereafter, he came before this honorable court in second appeal to 15/18, which was not maintainable on 29th August 1989. And thereafter, the frivolous suit was filed to create hurdles in my execution proceeding 3/85. And on several occasions, he came before this honorable court to create hurdles on the delivery of possession by the court. So ultimately, he lost the case. And I have filed the date chart for your lordship's. Ultimately, he lost the case at the apex court on dated 26th October 2007. And he had also invoked your honor's jurisdiction in a writ appeal 44 of 2007, which was dismissed on 26th September 2007. Will be called for your honor's perusal, so that your honor can arrive in a right conclusion and dispense justice at your end, the person seeking the relief. So
My lord.
You're for the other side.
My lord.
Just come to the impugned order.
My lord.
Para 3. Can you read the para 3 of the impugned order?
My lord.
Just read it.
My lord, for deciding an issue as to whether a suit is hit by the principles of res judicata, the court must come to a conclusion as to whether the court deciding the earlier suit had jurisdiction to do so. If a court having no jurisdiction decides a suit, the judgment will be a nullity in the eye of law and shall not stand in the way of the parties to agitate the same dispute in another suit. In view of the aforesaid position of law, I find that the trial is right in holding that title suit number 15 of 1990 was not hit by principles of res judicata. My lords, my suit is that subsequent title suit number 15 of 90. My lords.
So then look at the last line. Why should the trial court again decide?
My lords.
Last 6 lines. In view of the foregoing discussion.
That it is needless to say.
I have no hesitation.
No, above that, sir. In view of the foregoing discussion.
My lords. I have no hesitation to set aside the impugned judgment, Annexure 1, and dispose of this writ petition with observation that the question of res judicata will be decided by the trial court once again.
Why should it again decide? Once the single judge has himself expressed the view,
my lords,
that it was not hit by the principle of res judicata, back for again deciding this?
My lords, this was decided on a preliminary issue. No evidences, no pleadings have been taken into consideration. My lords, whether that subject matter of suit was without the jurisdiction of the
but once this single judge has said,
my lord,
I find the trial court was right in holding that it is not hit by the principle of res judicata, that single judge has said that.
My lord.
Just the previous page, sir.
My lord.
In view of the above position in law,
my lord,
I find that the trial court was right in holding that title suit is not hit.
My lord.
Why should the trial court again decide that? Once you have agreed with the trial court that it is not hit, why is the single judge again saying that the trial court will now decide again?
My lord, your lordship,
this is unnecessary.
My lord.
If the single judge is agreeing that it is not hit by res judicata, why should it be sent back?
My lords, your lordships may observe that second suit is not hit by res judicata.
We don't have to say the single judge has said that.
My lords.
Ah. Yeah, correct. Correct. There's no need to decide res judicata again. All right.
This is a third round case of him. This is the writ application which was presented by a single judge. Before single judge was a third attempt of him.
Anyway, sir, let them now decide the other issues. You say the present appeal is directed against the impugned judgment dated 30th June 2005 of the learned single judge, allowing writ petition civil 843 of 2005 filed by respondent number 1 herein against the judgment dated 13th May 2005 passed by the Additional District Judge Badrak in CRP number 25 2003. Full stop. Paragraph. The said CRP 25 2003 been filed by the present appellants challenging an order dated 12th November 2003 passed by the trial court holding that title suit number 15 of 1990 filed by the respondent. It is your suit.
No. Yes, ma'am.
Yes.
I am the
Sir,
plaintiff.
don't confuse, sir. It is your suit. Don't say no.
No, my lord.
It is your suit only.
My lord.
Title suit number 15 of 1990 filed by the respondent was not hit by the principles of res judicata. Paragraph. Interestingly, in the impugned order, the trial court came to the conclusion, categorical conclusion as under open quotation. In impugned order, the learned single judge came to the categorical conclusion as under open quotation. I find that the trial court was right in holding the title suit number 15 of 1990 was not hit by the principles of res judicata, unquote. Paragraph. However, having come to the above conclusion, the learned single judge, while setting aside the judgment of the learned ADJ in CRP number 25 2003, strangely again issued a direction that, open quotation, the question of res judicata will be decided by the trial court once again, along with all other issues, without being influenced by any of the orders passed, unquote. Paragraph. This was a completely unnecessary order. Full stop. Once the learned single judge had come to the categorical conclusion that title suit number 15 of 1990 was not hit by the principles of res judicata, there was no occasion for the issue to again be examined by the trial court with all other issues. Paragraph. Consequently, while setting aside that portion of the impugned order which requires the trial court to, open quotation, once again, unquote, decide the issue of res judicata, this court directs that the trial court will now proceed with all other issues in accordance with law.
But all other issues have already decided.
Paragraph. The interim order is vacated, the writ appeal is disposed of.
My lords,
Interim
may I
order-
pray, my lords? My lords, to 90.
It will be open to the parties to request the trial court to expedite the disposal of the suit. All right.
The issues have already decided.
All right. All right.
Okay.
Supplementary list item number 3. Item number 3.
None appears dismissed.
Item number 4.
None appears dismissed.
Supplementary list item number 5.
May I please, Your Lordship? Lordship, the certified copy of the order has not been filed. 1 week time to file.
No. Just tell us what the matter is about.
Your Lordship. Lordship, the review petition arises out of the order dated 8/1/2015, your lordship, passed by this honorable court. The case of the petitioner has been dismissed on two grounds, your lordship. First, that the order of the appointment of the OP number 5 has not been annexed. And secondly, your lordship, no plausible explanation for the delay has been given in the petition. But the order of the appointment of OP number 5 was annexed in the writ petition, your lordship, under annexure 5.
So the SLP against this has been dismissed.
Yes, your lordship.
Then there's a question of review after that.
Your lordship, even after the dismissal of SLP, your lordship,
Without reserving leave, you have to ask permission of the Supreme Court saying, I want to withdraw to go in a review. You have done nothing of that sort. Come to page 47.
lordship.
Heard and dismissed.
Yes, your lordship. I'm citing a judgment of the Honorable Supreme Court, your lordship, in which has been stated that even after the dismissal of SLP, the review is maintainable, your lordship.
All right. Okay, what's the ground for review? What's the ground for review? It's all right, sir. What is the ground for review? Ask him to stay back. What is the ground for review?
Well, these two grounds is there. First ground is that the factual facts is not brought to the court properly, for which the OBC certificate and SCBC, there is a controversy as regard to OBC certificates. What problem is this application, my lord? The petitioner is coming a form of PIL. That's why the court observed that, because if you have personal interest, the PIL cannot be maintained. But here is the case, even though he has a personal interest, but there's a prima facie it is clarified that no, this OBC certificate, SCBC is a controversy. They have not taken anything according to the rules. That's why an appointment has been given. It's a prima facie, it is found that the irregularity is there, which was not brought to the notice because only ground of PIL it was dismissed. Number one. Another, may I say?
Place the fact. Place the facts.
Yes, my lord.
Now, why this petition was filed?
Yes, sir, my lord, it is a case. The petitioner is one of the applicant for the post of business administration as a associate officer. There is advertisement are published, and I am one of the applicant. I am on the serial number 11. The select person he is selected, he was in serial number 9. That is annexure.
So the easier thing is to seek review of a certain order.
My lord.
You want to seek review of a certain order.
My lord.
Easiest thing is to read that order, sir.
Yes.
Easiest way to argue is to read that order of which you are seeking review.
My lord. My humble prayer before my lord, this order which against which was filed, it was misplaced in my file.
We'll give you that.
Please.
Give him the file. The writ petition file.
Yes. May I pray, my lord? Can it be passed over then after launch? It can.
No.
Or it can.
Take out that order. Take out that 8 January order so that he does not have to search for it.
Sorry, my lord, we are also not filing this.
Kindly read that order, sir.
Yes.
Kindly read it aloud, Mr. Padi.
Yes, yes.
Ah.
The petition spread inter alia for a direction opposite partner 1 and 2, the strict compliance of the provision of the Orissa Reservation of Post and Service of the Socially Economic Backward Classes Act 2008 for the short hearing after refer to the ORPC and SCBC Act. An ancillary prayer has also been made to direct the opposite party number 1 and 2 to take steps against the opposite party number 5. The petitioner is a lecturer in the Department of Business Administration, Utkal University, Banibir, Punishore. She belongs to the social economic backward classes and served in terms of the SCBC. She has writ petition as a public interest litigation. Her grievance is that the Vice Chancellor Utkal University, Banibir, Bhubaneswar, opposite partner 1, issued an advertisement on 22/5/2009 inviting application for eligible candidates for teaching post under the post of graduate department and Constituent College. Pursuant to the same, she applied for the post of lecturer. Business Administration Department under the SCBC category. As per the advertisement, the post was for SCBC candidate. Only 11 candidates applied for the said post. She secured 47.05 marks, whereas the opposite party number 5 is secured 51 marks in the merit list. The name of the opposite party number 5 found place at the serial number 1, and the petitioner's name found place at the serial number 2. She came to know that the opposite party number 5 obtained a caste certificate in the year 1988. She made an application under the RTI Act to provide information. Finally, the required information was provided to her on 21/11/2012. Therefore, she found that the opposite party number 5, who was selected under the SCBC category, obtained a caste certificate on 3/7/1998. Thus, on the basis of the invalid caste certificate, the opposite party number 1 and 2 selected the opposite party number 5. It is further stated that the father of the opposite party number 5 was a manager of State Bank of India. Thus, the opposite party number 5 is a candidate of the criminal. Had the Dr. Chaudhary, the petitioner who appeared in person, and the T. Patnaik Land Council appeared for the OP number 1 and 2 Utkal University. In course of hearing, the court asked a specific question to the petitioner that as to nature of the relief prayer by the petitioner, the said question was asked in view of the fact that the first and third paragraphs of the writ petition shows that the writ petition is filed by way of public interest litigation and the petitioner has no personal interest. The prayer made in the writ petition is for a direction to the opposite party number 1 and 2 for strict compliance of the provision of the SCBC Act 2008 and the take steps against the opposite number 5. The petitioner submits that the challenges the selection of the opposite party number 5 to the post of lecturer in the Department of Business Administration and confines her prayer to the same. The order of the appointment of opposite party number 5 is not been examined. No prayer has been made to the quash the same as the petition appears in person. This court heard and said issue. The selection to the post of lecturer in the business administration was made in the year 2009. The opposite party number 5 is still continuing as a lecturer till date, though the selection was made in the year 2009. The same was challenged after lapse of 5 years. The further the petitioner is continuing as a lecturer in the aforesaid department. No plausible examination has been provided for the belatedly approaching the writ court. In view of the same, we are not trying to entertain this application. According to the writ petition is dismissed.
Tell us what is the error? What is the error in the face of the record?
Only one thing there is one observation that it is a PIL. Admittedly, because it is come under the form of PIL, this petitioner prayer cannot be entertained. But simultaneously, I am placing before my lord that my lord has observed that we have not given the appointment letter, and also that the selection we have submitted the application after 5 years before the court. But facts remain that we have obtained the certificate of the selected candidate OP number 5 after getting the information under the RTI Act.
When did you get it?
My lord, we have get it in 2014.
No, sir. That's not correct.
12. But it was written 21/11/2012. But my record says that this RTI information was received by the informant Because, my lord, we have filed this separate application, the RTA Act. So one information we have gathered, we have somebody application. Thereafter, another information we gathered, there we get the same. Unless until we have got the certificate which was challenged for, my lord, the SEBC, OBC, which was getting since 2088. After lapse of 11 years, they are coming and submit the application. This certificate issued by the authority before 11 years. It was submitted before the authority and that was taken into consideration. Admittedly, fact that he was the criminal and his father was working as a manager of the State Bank of India. So this certificate submitted by his cannot be accepted by the authority. This is the only ground, my lord. This is all.
No grounds made out for review. Review petitions dismissed. All right. Thank you.
May
Ask him to
I
correct it.
pray one thing, my lord? These two decisions we have searched that can be taken into consideration.
We've taken it into consideration. sir.
Obliged.
Thank you. Thank you.
May I please? My lord, there is a delay of more than 3.5 years. My lord, may without recording my submission, may dispose of on the ground of delay only.
The delay of 1344 days is not properly explained. MC number so and so is dismissed. Consequent review petitions dismissed.
Obliged, my lord.
Item number 7, I am praying for adjournment. My younger brother expired yesterday, madam.
Counsel for the petitioner is stated to be in some personal difficulty. (29th March).
Obliged, madam.
Supplementary list item number 8.
None appears dismissed. Yes.
Well, in item number 8, well, in connected matters, your lordship may kindly take up WA number 584 of 2019.
Let's call out one by one, sir. Call out WA77.
WA 77 of 2019.
None appears for the appellant dismissed. Next call out.
WA 83 of 2019.
None appears dismissed. Now you appear.
Yes.
WA 584 of 2019.
But in this case, I have challenged the order passed by the Leonard Single Judge under Annexure 7. My lord, the background of the case is like this. The appellant was appointed as an education volunteer on 3/12/2005, that is under Annexure 1.
Oh, sorry. Sir, apparently
Yes.
584 of 19 was not asked to be listed today.
Oh,
584 of 18 was asked to be
yes.
listed.
Yes. Then, my lord,
So we don't have 584 of
Yes.
19, is it?
let it come some other day.
So then that is, we need to pass. No, file is not before us. 584 is not. (584 of 2018). List on 29 March. And then in 584 of 2019. List on 27th February.
27th February. Item number 9.
My lord, the delay of 33 days.
Correct.
This is a case where,
Correct. Delays condoned. Yes.
obviously. Now here the appeal has been preferred against the order dismissing the restoration application, which was filed to restore the review application. My lord. Little background of the case is necessary in the sense, after the dismissal of the writ petition, a special petition was preferred by the petitioner. That was dismissed list of special petition, and thereafter my lord, review application was filed. Review application unfortunately could not be attended to, and that was dismissed. A restoration application having been filed, that having been rejected, this has been filed. Now, one of the questions that your lordship was pleased to pose just few items before was with regard to entertainment of a review application post facto the dismissal of
It's all right. It's all right.
Well,
Tell us.
that it has been
Now,
held.
now,
Well.
this is more than that is why should we interfere with this 4/12/2018 order? That's the
But
question.
2018, my lord, your lordship will see. Also, recently, my lord, there was an occasion of dealing with such kind of matter by the Honorable Appellate Court, wherein it was also interfered with after long after. But here I beg to point out from their own document, your lordship will find my termination was illegal. The post for manager legal service was advertised. This petitioner, who happens to be advocate of Barampur Bar, he applied for the post. Now, my lord, at that relevant point of time, there are some agitations, some cases were en masse registered against the members of the Bar Association. Now, your lordship will kindly see the appointment order. One of the condition which is taken aid of to terminate my service is as page 23. Page 23, your lordship. May I just place it 3 lines only, my lord? Your appointment in bank service shall be liable to be terminated forthwith without any notice if any of the information documents submitted by you are found to be false, incorrect. Now, a member of the Bar Association there intimated my employer that I have some criminal cases with regard to that agitation in the bar. Now, post facto that information being received, a notice was served on me asking me to explain as to why my lord, my service should not be terminated for non-disclosure of that criminal case. Now, my lord, I explained saying that this has the general case registered, the Secretary of the Bar Association was taking care of. I was not aware of it, and there was no requirement of my lord furnishing that so far as the appointment condition is concerned. Now, my lord, the law department opinion, the respondent of employer sought for opinion of their own law department, Annex 7 at page 37. Now, I beg to draw only your lordship's kind attention to few paragraphs what the law department says. Law department says there was no specific requirement of asking the appellant, present appellant, furnishing with regard to any criminal case pending against him. Even assuming that this criminal case was there and not disclosed, this is not affecting the character of the person, but one of the factors was also character. Because this is a general case registered against all members of the bar. Now, and they opine that is not the recourse. Your lordship will see kindly page 37 and page 40. Also the relevant page 37, paragraph 2 also, the opinion your lordship will kindly see. Now, post facto this, despite this position, the termination order was issued in a single line at page 43, in just without assigning any reason or as to why they are differing from the opinion of their own law department, the order was issued. I preferred a repetition. Now, considering all these things, it was held that no, your writ petition is not entertainable because you are not disclosed. Now, I preferred SLP. SLP was dismissed at the stage of SLP stage, and that will not stand as a bar. A review application was filed. Now, your lordship will see, my lord, the dismissal of the review application at page 73, my lord. Only one line order. Review has not been also, no grounds has been considered. Likewise, the restoration application also has been dismissed with a one line order, without my lord indicating any reason as to why my restoration petition was not, the plea taken in the restoration petition was justified or not. Now, my lord, so far as the overall fact situation is concerned, if your lordship will consider vis-a-vis the recent decision of the Honorable Appellate Court, but I am not only relying upon the decision of the Appellate Court, I beg to submit on facts. On facts, my lord, your lordship will see the Honorable High Court was pleased to quash those criminal cases, including the petitioner. Post facto, of course, my lord, the disposal of the writ petition, and pre facto, the filing of the review application. So therefore, the criminal cases have been effaced. And your lordship will see the very appointment order nowhere imposes a condition that there should be a disclosure, and he has explained why he had not disclosed. But it was not an individual criminal case or an individual act. Maybe, my lord, here also we fall victim to the strikes at times, even if some of the members are not desirous of to be part of that also. So this was the situation how a criminal case was registered, and that was against a group, a mass. It was not an individual act where he was implicated. And the law department analyzes it, and your lordship, just if your lordship pardon me to repeat it again, under Annexure 7, that they give a exhaustive opinion and their own law department assigning reasons why he should not be terminated and how he has not misled the authorities to appoint him by not disclosing that criminal case. So in this background of the matter, with your lordship's kind permission, may I just the Honorable Appeals Court also recently had the opinion. Yeah, would take a few. I'll submit one thing. Strike has made many lawyers suffer. Maybe this appellant is one of the victims of those strikes. My lord, I cannot say that it was justified. I never also support it either. This is the background on which, my lord, I humbly pray. My review application, if at all your lordship will be inclined to interfere, my lord, it will be a question of subject to your lordship's kind permission, relegating it for consideration of my review application, nothing beyond that. But here your lordship has been pleased to see both the review and the restoration application have suffered dismissal, my lord, without any reason whatsoever. But this is the background. Their own authority says they have a law department in place and they are a statutory authority, and their own department says that no, he is not liable for termination because he has not violated any of the conditions of the appointment order. So therefore, in this background, my lord, I humbly pray your lordship may kindly consider this matter both on the ground of sympathy and also the legal position and factual position available in the case, my lord.
All right. This writ appeal is directed against an order, the learned single judge declining to restore a review petition which was dismissed for default. The review petition itself was filed after dismissal of the special leave petition by the Supreme Court against the original order dated 23rd April 2014. Having heard learned counsel for the parties, the court is not inclined to interfere with the appeal order. The writ appeal is dismissed.
Obliged.
Item number 10.
May I please also. Here, my lord, I have challenged the order of the learned single judge under Annexure 15. Your lordship may kindly turn to page 131. My lord may kindly come to the third paragraph of that order. Referring to the document at Annexure 5, an objection to the application for condonation of delay filed by the appellant therein, Sri Mahapatra learned counsel for the petitioner submitted that looking documents at page 23 of the brief, it is clear that the same is a postage at the instance of the present opposite party number 4 and cannot be construed as a notice issued by the appellate tribunal. It is in the above premises, the learned counsel for the petitioner submitted that the observation as well as the findings of the State Education Tribunal involving Annexure 6 becomes fact. Considering this submission of the learned counsel for the petitioner and on perusal of the order by Annexure 2, this court finds admittedly the order at Annexure 2 involving the Education Appeal number 14 of 2007 is without consideration of the present petitioner. Similarly, looking to the document appended to Annexure 5, this court finds learned counsel for the petitioner satisfies that the registered document sent through material at page 23 of the brief cannot be construed to be a document to have been sent by the State Education Tribunal involving the appeal. Under the circumstances, and as this court finds, in fact, Annexure 2 is an outcome of non-consideration of the case of the petitioner, this court feels inclined to interfere in the impugned order by Annexure 4 as well as Annexure 6. As a consequence, this court interfering in the order by Annexure 4 and 6 sets same, and as the Education Appeal number 14 of 2007 needs re-adjudication, the Education Appeal number 14 of 2007 is remitted back to the State Education Tribunal for rehearing of the appeal involved therein, giving opportunity of hearing to both the sides. My lord, I have challenged this order mainly on the ground, but this matter was listed on 1/2/2019. On that date, the respondent number 1, for whom I am representing, my lord, I missed the cause list and I could not attend the court, and this order was passed in my absence. Then, my lord, so far as the merit of the case is concerned, your lordship may kindly come to page 10 of the brief.
So what is the prejudice by the impugned order to you?
My lord,
What is the prejudice
well,
cause?
prejudice is, my lord, I succeeded in the State Education Tribunal. My services were terminated. I approached the State Education Tribunal under Section 10A of the Orissa Education Act because I was an aided educational institution. My lord, the tribunal also passed an interim order not to appoint anybody in my post. In violation of the interim order, my lord, the name of the appellant, the name of the, my lord, the appellant was, the name of the respondent number 1 was recommended. Then, my lord, I brought that fact to the notice of the tribunal, and the learned tribunal passed an interim order, your lordship may kindly turn to page 10. I have quoted that order. Here, my lord, the only point is whether notice was served upon the respondent number 1 or not. That is the only question. On that ground, the learned single judge has allowed the writ application. My lord, may kindly come to page 10. I have quoted the order of the tribunal dated 16/5/2009. My lord, this was not brought to the notice of the learned single judge. Advocate for the appellant appears and files consolidated appeal memo. Respondent number 1 is absent. The government advocate appearing on behalf of respondent numbers 2 and 3 appears and files Hajira. Appellant is directed to serve the copy of the appeal memo on the newly implemented respondent number 4. Respondent number 4 is present, respondent number 1. Pursuant to this order dated 6/5/2009, your lordship may kindly come, page 128. I served a notice by registered post, which came back with an endorsement. My lord, may kindly come to page 128. That postal endorsement is there. Addressee refused. The respondent number 1 refused to receive the notice. And your lordship knows that once it is received, once it is refused, it is deemed to have been served. But this fact was not brought to the notice of the learned single judge, and the learned single judge came to an erroneous conclusion that notice could not be served,
So
and
this
accordingly
notice-
set aside the order.
So this notice didn't go from the tribunal.
My lord, yes, my lord, here, my
So
lord,
it's not the same thing, sir.
no, tribunal directed.
You're missing out the most essential fact in this whole narration. I don't know how it is advantageous to you to not place the correct fact before us.
No, my lord, here,
I don't know why.
my lord, here, your lordship,
Simple, the nub of the impugned order is that this notice didn't go from the tribunal and therefore it's not a valid notice. That is what you have to address.
my lord, your lordship is absolutely correct. My lord,
After telling you what the point, naturally you have to say I'm absolutely correct. The
Well,
question is, why did you not place this point before us? Isn't that the only point in this entire
my
appeal?
lord, yes, your lordship may kindly turn to page 10. In page 10, my lord, I have quoted the order of the tribunal. In page 10, at 16/5/2009, I my lord, sent a registered notice on the respondent number 1, which came back with an endorsement that he refused to receive the same. So not that, my lord, I have so moto served a notice. So this was pursuant to the direction of the tribunal, that order I have quoted at page 10.
You're not inclined. Yes.
Rule 7, my
The
lord,
present-
clearly
So we are dismissing the writ appeal. If
Oh,
you
sorry.
insist on arguing, we might change our mind. The present writ appeal is directed against an order dated 1st December 2019, passed by the learned single judge, disposing of writ petition civil 2207 of 2011, filed by the respondent number 1, whereby the order dated April 15th, 2010 of the State Education Tribunal in appeal number 14 of 2007. Filed by the present appellant, as well as the subsequent order dated (13/9, 2010). Sorry. Subsequent order dated 23/10, 2010, declining to recall the said order, was set aside by the learned single judge, and the matter was remanded to the State Education Tribunal for a fresh disposal of the appeal in accordance with law. Paragraph. It must be noticed at this stage that while directing notice to issue in the present appeal on 19th March 2019, the impugn order of the learned single judge was stayed. Paragraph. The reason that weighed with the legal judge in setting aside the aforementioned orders of the Education Tribunal was that the notice on respondent, paragraph, comma, the main contesting party in the appeal before the tribunal, comma, was not served, was not the one issued by the tribunal itself, but it was only the private notice of the present appellant, which was shown to have been refused by the respondent. Full stop. It was rightly held by the learned single judge that the said notice could not have been construed to be a document by the State Education Tribunal in the appeal filed by the present appellant. Paragraph, having heard learned counsel of the parties, the court is unable to find any legal error having been committed by the learned single judge that calls for interference. Paragraph. It is now directed that the aforementioned Education Appeal 14 of 2007, filed by the present appellant, will be listed before the State Education Tribunal on 19 December 2022, on which date both parties will appear. Both parties, that is the appellant and respondent 1, will remain present through the respective counsel. So the Education Tribunal is requested to then proceed with the hearing of the appeal on merits and dispose it off as expeditiously as possible, preferably within a period of 4 months from that date. The writ appeal is disposed of in the above terms.
Item number 11.
May I please, Your Lord? My Lord, I am a licensee of Umfed Booth. An order of eviction was passed against me under Annexure 4 to the writ petition. Without hearing me, no proceeding, nothing. I approached this court and the Honorable Single Judge passed an order that is impugned here. Your Lordship may kindly see. The Honorable Single Judge is of the view that the eviction order, I should have approached the municipal corporation again. Lord, I am there since last 7 years, prior to filing of the writ petition. No hindrance to anybody. And Your Lordship may kindly see Annexure 4 to the writ petition. Notice was issued in 19. Notice to both the respondents was issued. Sorry, madam.
What is your prayer in the writ petition?
To quash Annexure 4. To quash Annexure 4.
Which is what?
That is the order of eviction, page 12 of the writ petition, Your Lordship may kindly see. The respondent number.
Do you have a statutory remedy against this kind of an order?
Well, this is an order not under any provision of law. Seeds Corporation rights, without any hearing to me, without any notice to me, the BMC passes an order of eviction. And I am a licensee existing then 7 years prior to filing of the writ petition.
By which, in the writ petition filed by the present appellant, it challenged an eviction order passed by the Bhubaneswar Municipal Corporation on 17th October 2017. The learned single judge has required the appellant to again approach the BMC without indicating under what provision of any law such a remedy was available to the appellant. Full stop. Paragraph, it must be noticed here that one of the main grounds on which the eviction order was challenged by the appellant was that it was without any prior notice to him. and without any opportunity of explaining his side of the case. Full stop. Indeed, a perusal of the impugn order does not seem to indicate that it was after issuing notice to the appellant. Paragraph. Nevertheless, the court is of the view that this was not a petition which could have been dismissed summarily at the threshold without examining the writ petition on merits. Paragraph. For the aforementioned, the court sets aside the impugn order dated 24 January 2018 of the learned single judge and restores writ petition civil 19017 of 2018 to the file of the learned single judge in the roster bench, where it will be listed for directions on 2nd January 2023. The learned single judge will proceed with the writ petition on merits and dispose it off as expeditiously as possible. The writ appeal is disposed of in remote terms.
Item number 12.
This order of status quo may continue.
Is there,
There is an order in the writ appeal.
Let's see that. Which date, sir?
The date is 10/4/19. 10th April 19.
Till such time, the status quo order passed by this court on 10/4/2019 will continue. All right.
Obliged.
Item number 12.
Item number 12, my lord. Lordship has already passed order to tag this writ appeal with some two other writ appeals. But today it has been listed wrongly, my lord. My lord, by the order 211 in writ appeal number 225/2019, Lordship has already tagged.
When is that coming up, sir?
That order is also up on 211.
When is that listed? Directed to be listed?
Directed to 22nd February.
All right. List on 22nd February.
22nd February.
Along with writ appeal 225/2019. All right.
Item 13. Item number 13.
None appears dismissed.
Item number 14.
My lord, the petitioner is a retired executive officer of the municipality. My lord, the only point, my lord, at the time, in the fresh admission stage, I was relying the rule 74B of Odisha Service Code and judgment of the Supreme Court, my lord, civil appeal to 13/2013. But my lord, I was praying before the court, honorable single judge, that I will place this judgment because, my lord, on holding up a higher, my lord, a promotional post, one is to, my lord, get the promotional pay as admissible under rule 74B of Odisha Service Code. Read with, my lord, the judgment cited, my lord, in this connection. Well, presently, the co-executive officers of the my lord, their writ petitions are pending before this single judge, and one of the case is allowed. So, my lord, by the same single judge, my lord, WPCOAC 2137/17. So, I pray, my lord, I will represent to the government because by citing the judgment of this annual court as Supreme Court, and also application of 74B of Odisha Service Code. So this may be considered by the respondent number 1.
Counsel for the appellant states that he would like to withdraw the present appeal with liberty to make a representation to respond by 1.
My lord.
Full stop. Accordingly, the appeal is disposed of as withdrawn with liberty is paid for. If such representation is made not later than 2nd January 2023, it shall be considered by respondent 1 and an appropriate reason order shall be passed thereon within a period of 3 months thereafter.
My lord, may I pray the judgment of this court I will place for the
all that we need not say in this, sir. It will be open to the appellant to urge all the points in the present appeal. Said representation for it.
Item number 15.
Relays control.
May I please, lords, challenge the 13/4/2019 passed by the Honorable Single Judge, wherein Single Judge held that the respondent is not coming under temporary service. So Lordship may kindly glance at page 11, para 11 of the judgment. Admittedly, the petitioner has joined under the CRPF, and as such, CRP Act 1949 is applicable to him. In exercise of power conferred by Section 18 of Central Reserve Police Force Act 1949, the Central Government Act, Central Reserve Police Force Rule 1955, procedure has been envisaged under Rule 18 to Rule 10 to Rule 18. With regard to recruitment, enlistment standard, health certificate, recruitment role, verification, plural marriage, period of service, discharge and discharge certificate, but the order impues does not say about any provision of CRPF Act and rules framed thereunder. Perusal of the order impues evident that the action has been taken in pursuant of provision to Sub-Rule 1 to Rule 5 of Central Civil Service Temporary Service Rule 1965, which reads as follows. Termination of temporary service. As the service of a temporary government servant shall be liable to termination at any time by a notice in writing giving either by the government servant to the appointing authority or by the appointing authority to the government servant. So Lordship can be the period of such notice shall be 1 month. The Honorable Single Judge held at page para 13, page 62, the term temporary service as defined above would mean service of a temporary government servant in a temporary post or officiating service in a permanent post under the Government of India. Therefore, the petitioner was elected and appointed RTGD and undergone training. His service cannot be termed as temporary service. More particularly, the definition of temporary clearly spread out that the temporary government servant in a temporary post or officiating post in a permanent post, and as such, the petitioner was neither holding a temporary post nor officiating in the service in permanent post. If he was not holding temporary service within the meaning of Sub-Rule D of Rule 2, consequently, Sub-Rule 1 of Rule 5 or 1965 cannot have been absent to the petitioner. I am challenging to this judge observation. My lord, the petitioner, while enrolled in CRPF, he has declared that by way of a format that he has no criminal antecedent. But during the course of inquiry, it is found that he was criminal antecedent. So far as CRPF Act rule is concerned, it is clearly Honorable Single Judge has emphasized Section 18 to Rule 18, 10 to Rule 18. Your Lordship may kindly visualize at Rule 16. It is clearly stated, period of service. All member of force shall be enrolled for a period of 3 years. During this period of engagement, they shall be liable to discharge at any time on 1 month's notice by the appointing authority. At the end of this period, those not given substantive status shall be considered for quasi-permanency under the provision of the Central Civil Service Temporary Service Rule 1965. It is clearly mentioned at Rule 16 of the CRPF Act 1949. Whereas Honorable Single Judge held that this Rules 10 to 18 has not been spelled out anything regarding the civil service temporary rule. The petition has been given, terminated on 9/11/2010. He was appointed on 18/4/10. In his appointment order, the Lordship may kindly glance at it is clearly spelled that his service is purely a temporary service. Page 45, the office order. In middle portion, in addition, they will also be entitled to free uniform ration, money, washing allowance, rent, accommodation, free railway, such and such, duty home, such and such, additional order. the appointment is purely temporary and likely to continue, but can be terminated at any time on 1 month notice during initial period of service, that is within 2 years. That is within 2 years. Here, within his appointment is 84 and his termination is 9/11. That means within 8 months, 7 months. During initial period, so that is within 2 years without assigning any reason. My Lord, so far as facts is concerned, so Lordship may kindly glance at the page 39. Before enrollment, the petition, the candidate has to declare warning, that is warning, page 39. The furnishing of false information or suppression of any factual information in the verification role, this is the verification role, would be a disqualification and is likely to render candidate unfit for employment under the government service. Lordship, second, detained, if detained, convicted, debarred, etc., subsequent to the completion of submission of this form, the details should be communicated immediately to the UPSC Commission or the authority to whom the verification role has been earlier, as the case may be, following which it will be deemed to be suppression of factual information. Immediately it was communicated, and the SP and collector had confirmed that criminal case is pending under section 302. And also he has declared under at page 49. What he has said, no. Have you ever been arrested, prosecuted, kept under detention of down and convicted by any court of law for any offense or disqualified by any public service commission from appearing its examination selection or debarred from taking any examination restricted by any university or any other? The answer is no. At page 49. My Lord, before the Honorable Single Judge, we have cited a judgment of Honorable Supreme Court, wherein it is...
You're appearing for the respondent.
My Lord.
How do you explain this?
Your Lordship may kindly say, my Lord, what is impugned is the order of termination. My Lord, all the reasons that have been assigned has been brought forward by way of counter affidavit. Your Lordship knows that, my Lord, counter affidavits cannot justify something which was not there initially. My Lord, the learned single judge has taken all those aspects into account and stated that once the public authority in its administrative powers did not assign reasons, counter affidavits cannot assign the same. My Lord, may kindly see the impugned order. The impugned order of the writ petition is there at page 25 of the writ, my Lord.
Give us the para number.
My Lord, page 25 of the writ petition, of the writ appeal.
Sir, the para number of the impugned order which you are reading, sir.
Oh, I'm sorry, my Lord. I was actually referring to Annexure 2 of the initial writ petition, my Lord. The relevant part of the impugned order that was initially under challenge in the writ petition itself. That is there at page 25 of the appeal, my Lord.
That is in para 15, my Lord, of the impugned order.
Carry on, sir.
My Lord, this impugned order in pursuance to proviso to sub-rule 1 of Rule 5 of the Central Civil Services Temporary Rules 1965, I, B.K. Topo, Commandant, hereby terminate forthwith the services of...
he was a temporary employee, isn't he?
My Lord.
He is in temporary service.
Indeed, Your Lordship. He is in temporary service.
There's a question of having to... it can be... The dismissal can be summary.
My Lord, that is, my Lord, I would respectfully submit, my Lord, that cannot be the scenario. My Lord, that summary, that reasons have to be given.
Why? In a temporary service, when it's within 5 months of your appointment, Why should the
My lord,
dismissal not be
reasons-
summary?
My lord, may kindly see the appeals impugned order.
In fact, I think that is made clear in the appointment order itself, isn't it?
My lord, the appointment order. My lord, may I rely on a decision, my lord? My lord, this is the case of Delhi Transport.
Yeah, this is different. Sir. Yeah, this is not about temporary appointments.
Yes, my lord, in permanent employment, my lord, they have categorically come to the conclusion that this kind of provision is called as an Henry VII clause because of the arbitrary hire and fire, my lord.
The context itself is different, sir.
Yes, your lord.
The complete different context.
My lord, in that event, may I pray for another date, my lord?
Why should you keep adjourning it? If you want to file a written note of arguments, you can. You say orders reserved. It will be open to the parties to file the respective written notes of arguments within a week.
Item number 16.
Item 16 due to the net problem, I am unable to prepare by the common next week any day, my lord. Next week any day. Due to my personal difficulty, I am unable to trace out the list. I prayed for next week.
You are able to trace out the list?
Yeah, because my net problem, I am unable to trace out.
What's the net problem? Nobody.
Because where I am residing, my lords, there is a problem of net in the last 2.5 months. Next week any date, my lords.
Counsel for the appellant. We just vacate the interim order. We'll vacate the interim order, sir.
Well, he's going to have permanent staff, my lord. Otherwise, you.
It's all right. We'll vacate it, sir. Whenever your net problem, all right, you can.
No, but next
file
week,
application
next week any day, my lords. Next week any day, my lords.
We'll vacate the interim order and then it can come any time.
He infects us, my lords. From tomorrow he will go no more in service.
We don't know all that. We don't know.
If
it is so urgent, if it is such a precarious matter, I'm sure you'd have got ready.
My lords.
You would have got ready. So if it is so urgent, if it is such a critical matter, you would have got ready in the appeal.
No, they go tomorrow, my lords. We got tomorrow, my lords.
We don't have. We have a heavy board, sir.
They come tomorrow, my lords.
We have a difficulty. We have a heavy board. We're prepared to pass over, sir. If you want to get ready, you get ready. You pass over, you get ready the matters. All right.
Item number 17.
May I please, Your Lordship? In the present appeal, I am challenging the order of the single judge dated 17th of July 2019, Your Lordship. Now, respondent number 6 has filed a counter affidavit, they not served a copy. And even for the management, nobody is appearing. If Your Lordship will allow me, I will place the matter on merit.
Yes, yes.
Yes, Your Lordship. I should kindly, before. I am
appearing for respondent number 6.
I prepared a very small and second date chart, Your Lordship, for Your Lordship's kind reference.
Yes, please.
The Lordship has decided this matter.
When?
Classical teacher.
1819.
350.
17. Item 17.
Item 17.
Sorry.
Sir. Actually, on 30th, 6th, 1992, the appellant was initially appointed as classical teacher in the school in question. It is a private unaided education at that point of time. Under Section 3B of the Odisha Education Act. On 1992, since the appellant remained unauthorized absent from 2002, the managing committee, by its letter dated 1992, asked for an explanation from the appellant. Then thereafter, Your Lordship, on 26 February 2003, the managing committee by letter dated 2003 asked her to explain as to why a disciplinary action shall not be taken against her for remaining unauthorized absent from 1302 till 26 February 2003, and to file a show cause by 10th of March, though the appellant had submitted leave application, which was acknowledged by the headmistress. Thereafter, Your Lordship, on 23rd of August, the managing committee passed a resolution to terminate the service of the appellant for unauthorized absent and disobedience by the appellant. Thereafter, my lordship, on 26th of September, this point number 6.
Just tell us in a short,
Yes,
your
Your
own words.
What happened in
Your
your lordship?
absence is for 5 months, correct?
Yes, Your lordship.
When did you submit the leave application?
My lordship, at this point, this juncture, I will file the order passed by the Director of Secondary Education, Your lordship. This is not on the record, through a memo. It was my specific case, Your lordship. Whatever leave application was submitted, it was duly acknowledged and accepted by the headmistress.
When did you submit the leave application?
The date, Your lordship. Your lordship will find it at pie number 4.
Yes.
Page number 2 of the memo. The history of the case is that petitioner Srimati Saraswati Devi was the appellant, having Shastri BA and Acharya and Siksha Shastri B.Ed from Rashtriya Sanskrit Sansthan, New Delhi, was duly selected and appointed as a classical teacher by the Secretary Managing Committee, Bhimasgiri Girls High School, Bhismagiri, District Ganjam, for a period of 89 days. By order dated 30/6/92, and the petitioner joined on 30/6/92. The said temporary appointment was extended from time to time and finally regularized from. I'll skip over this part. Next paragraph.
There is something wrong here, sir.
My lordship.
The said temporary appointment was extended from time to time.
And I was regularized thereafter.
No. By an order dated 36/94.
Yes, Your lordship.
I
was regularized.
Then she worked for 10 years up to 12/9/2002.
Yes, Your lordship. Thereafter, the relevant paragraph, Your lordship. The appellant was discharging her duties of classical teacher from 30/6/92 with best satisfaction to her authorities. But she remained on leave with effect from 13/9/2002 to 13/12/2002. But she was asked to explain of her absence by 4/10/2002 in letter number 27 dated 19/2002 of the headmistress. In continuation of the said letter, the headmistress again asked to explain her absence.
So 1 minute, you have in your list of dates.
Yes, Your lordship.
Said that she had submitted leave application.
Yes, Your lordship.
When did you submit leave application? When I asked you that question, you asked me to read this order.
Yes, Your lordship.
This order does not say when you submitted a leave application.
Actually, that is also not borne on record, Your lordship.
That's the whole point, sir. The entire point of the case is that if you stay unauthorizedly absent without even submitting a leave application, you cannot later validate that leave. Correct? Absence. You can't validate that absence.
With due respect to Your lordship, I should kindly refer to the next lines because it is duly approved. That is my entire case. But she asked her to explain of her absence by 4/2002 by letter number so and so of the headmistress. In continuance of the said letter, the headmistress again asked to explain her absence by letter number 35 dated 1/11/2002, and the petitioner has submitted reply on 8/11/2002 stating that the letter dated 19/2002 of the headmistress has not been received by her, and she submitted another application for leave from.
Where is this another application? Where is the first application? Where is the first application itself, sir? Where's the question of another application?
Yes, Your lordship. No, it was approved. Now they are saying, Your lordship.
So acknowledging is different from approving. All right. You acknowledge somebody gives you a leave application, you acknowledge receipt of the leave application.
Yes, Your lordship.
That's not the same thing as approving the leave.
My lordship.
There are two different things. Where is the order of the headmistress approving or sanctioning the leave?
My lordship.
Where is that? When was the school reopening?
Yes, Your lordship.
The 25th.
School was reopening on 25th of May 2003.
So you did not join in the reopening also, sir.
No, my lordship, kindly the relevant inquiry made by the director.
No, 1 minute. Second line of this page 3.
Yes, your lordship.
You said you were asked to resume duty by 10/3/2003.
Thereafter, and the letter were issued.
No, 1 minute. Did you join duty on 10/3?
That was not communicated to me, your lordship.
So you don't follow up also. You're in a very convenient place. You're on leave anyway. You're not in any compulsion to go back to school. You submit a leave application. You don't follow up on that leave application. So you continued remaining on leave. It's quite convenient. You got a permanent job somewhere. You stay on leave, don't submit a leave application. Whenever you feel like you submit a leave application, you do remaining on leave. You say, whenever they will tell me, if I get intimation, then I will go and join duty. Otherwise, I will no compulsion.
I bow down to your lordship.
What is this conduct? But you're a teacher, right?
Yes, your lordship. But your lordship, the finding what I've given by the director is,
yes.
Can I just place your lordship to, in case I can change your lordship's mind?
You answer the question first. As a teacher, how do you expect to just stay away like this endless number of months? And you expect authorities are not supposed to do anything?
Actually, my lordship, they have terminated me directly without following the principle of natural justice.
You're not even there, sir. Where is natural justice? Where's the question of even serving you, hearing you?
At least
you're a person permanently absconding.
That is not the case, actually, your lordship.
I know, because he's not to be found. See, you're like the rare bird. You just don't appear.
Actually, your lordship, I have appeared. Thereafter, I have submitted again the leave application, which was
the only thing that made you appear was your termination letter. Otherwise, you would not have appeared.
That was not communicated to me, your lordship. That is a specific case. I should kindly see.
Yes.
What has happened, your lordship?
Yes.
The petitioner to resume on her duty on the reopening of the school and finally by letter number dated.
See, others in the CRPF, BSF, all this happens. Somebody just walks out and never comes back. Then they will say, no, I was down with this typhoid. I kept sending medical certificates, leave application. Wherever I was, I kept sending that, hoping that they will sanction the leave. Of course, the courts never accept those applications. Explanation. Here, you don't even have those explanations. Till now, even you are not aware as lawyer, what made her stay away from duty? Any explanation?
Because of her mother-in-law ill health, your lord.
No, where? Nothing has come. This is something new.
It is in the counter affidavit filed by the inspector of school, your lordship. The finding is there, your lordship. It is in my favor. So should you just allow me? I will just place it.
All right, place it. We are not stopping you. Yes.
Now, the school authorities has made a newspaper publication about suspension of the petitioner with effect of 22/7/2003 and termination from 23/8/2003. But the suspension order has not been filed in the written note of comments. The submission of the headmistress that the termination letter number 6 of 23/2003 was sent to the petitioner through RP, and the letter unwritten postal remark with the address is always absent is not supported by postal evidence. The next paragraph, your lordship. The headmistress, in her written note of comments at paragraph 20, and the secretary in his report have stated that the petitioner is working as teacher in Maa Saraswati Shishu Mandir, Diamond Tank Road, Berhampur, 2002. Ms. Mansi Das, in her written note of comments, has stated that the petitioner of termination of her service has joined as assistant teacher in the state Shishu Mandir on 1/7/2004, and to his effect, intimation collected by her from the CIS Ganjam under RTA Act 2005 has been filed. So it is held that the school authorities have filed wrong comments. Now, thereafter, your lordship, at para 9, the petitioner on the had submitted that she was on leave from 39/2002 to 13/2002, which was extended from time to time till 5/1/2004, and reported for duty on 6/1/2004. The petitioner has submitted proof of her under certificate of pushing to this effect. She was not allowed 6/1/2004, which amounts to termination. The termination letter dated 28/3/2003 as well as newspaper publication was not within her knowledge. Now, thereafter, your lordship, the director held that termination of service is the highest punishment. I have given proof, your lordship, before the director when it was extended from time to time, my leave application. But at para 9, your lordship. Now, at para 10, sorry, the subsequent paragraph, continuation of paragraph 9, termination of service is the highest punishment and it is awarded upon employee with proper proceeding and is framing of charges, defense by the delinquent inquiry and show cause for proposed termination, which has not been followed by the school authorities. Moreover, the termination is not proportionate to the offences if committed. So it is held that the action of the managing committee is not as per law. Hence, my termination order was set aside. Now, my lordship, I will also bring to the notice of this honourable court with regard to the finding of the honourable single judge at paragraph 7, page number 42, running page 11. All these aspects has not been considered by this honourable single judge. I'm candidly saying, your lordship. Why I'm saying so? At paragraph 7, I'm just placing it, your lordship. The above being the pleaded facts and rival submissions of the learned counsel for the parties, it is to be seen whether the order impugned passed by Director Secondary Education Orissa is without jurisdiction or legal tenable. The appeal in question was filed by the opposite party number 6, pursuant to government notification dated 27/3/1983, and in consonance with the order dated 22/4/2008, passed by this court in WPC number so and so. Even at the appellant stage, the petitioner raised preliminary objection with regard to integrity of the appeal. Because the school in question by the time the appeal was preferred has become an education institution. Thereby, as per section 10A of the Orissa Education Act, OP number 6 could have preferred appeal before the State Education Tribunal, but such question of maintainability has not been answered by the director in its order so passed in Action 15 dated 17/11/2009. So far as factuality of the case is concerned, the director has not disputed such position and taken note of such fact in paragraph 5 of the order impugned itself, and specifically stated that opportunity was given to the OP number 6 the committee, and she was also intimated about termination of her service with effect to 23/8/2003. Pursuant to managing committee resolution dated 18/7/2003, the school authority also made a newspaper publication about the suspicion of OP number 6 with effect from 22/7/2003 and also with regard to her termination from 23/8/2003. Furthermore, the order of termination dated 23/8/2003 was communicated to the petitioner by registered post with AD, but it was always returned with a postal remark that this is always absent. Therefore, it was published in the newspaper Anupam Bharat. As such, after termination, OP number 6 had joined in Shishri Mandir on 2004 as assistant teacher. Such information was obtained under the RTI Act 2005 and placed before the director for consideration. But without assigning reasons, the director passed the order stating that the termination of service is highest punishment and is awarded upon employee with proper proceeding. That is framing of charges, defense by the delinquent, inquiry, and show cause for termination. It has not been followed by the school authorities. And that termination is not proportionate to the offense if committed. While giving such observation, the director has failed to take note of the fact that the managing committee had given opportunity by calling her to show cause, but OP number 6 did not respond to the same. Therefore, the order impugned portion termination order dated 23/2003 passed by the director is an outcome of non-application of mind. As such, the director has passed the order impugned without following due procedure of law and the observation so made by the order termination. Now, you may kindly see the counter affidavit in the file is the writ application by the inspector of school. What was the actual fact? At page 50, your lordship. Is I'm saying so, your lordship. Page 50 and section 14, your lordship. Paragraph 4. That as regards to the amendment made in paragraph 5, it is only submitted that in response to the explanation called by the managing committee of the school by letter number so and so and reminder letter number so and so, the OP number 6 submitted her reply on 8/11/2002, stating that the letter dated 19/2002 of the managing committee of the school as by her. Further, a leave application for the period of so and so has been submitted by the OP number 6. Why I'm saying so? Because the director has found that they have allowed me to be on leave and they have asked.
That is all wrong, sir. Completely. Nobody allowed you to remain on leave. In fact, they asked you to join on, even by this director's order, they asked you to join by 10/3/2003. Now you conveniently say that was never, I never knew that.
Now they have also extended it to 23rd of April.
Anyone who's desperate to work will come and report for duty. All right.
My lordship.
Your case, you say till you roll out a red carpet to me, I will not even come near the school.
But that is not only the case.
That's exactly what it is. You are asked to resume duty on 10/3, you do not turn up. On 25/5, you're asked to resume, you don't turn up.
My lordship, I bow down.
This is an endless case of the school waiting for you one fine day when you will appear, and you never appear.
My lordship, I also agree with the statement of your lordship, but the fact is, I have given the proof of the director of secondary education that my leave was granted. I should kindly see the order passed director of secondary education.
Yes.
What rebuttal has the managing committee produced, your lordship?
All right.
They have not even appeared before the honorable single judge.
All right.
I should kindly see the order passed by the honorable director of secondary education, your lordship.
Yes.
What he has stated.
Yes.
In paragraph 9.
Yes.
At page 2-3, your lordship.
Right.
The petitioner, on the other hand, has submitted that she was on leave from 13/2002 to 13/2002, has extended from time to time till 5/2004.
Who extended from time to time? This is excellent. You keep extending your leave from time to time.
But my lordship, suppose the proof. When it was authorized,
Who gave you leave, first of all, and you give yourself leave and you keep extending your leave from time to time?
No, my lordship, I have submitted the proof. The endorsement by the school itself.
I think you've not. Anyway, all right, you carry on. You carry on. Ask him to come back now. And I want to know if you get self. Yeah. All right.
Can I request your lordship? Let the managing committee appear. If they says it was not been approved, then I have no case, your lordship. They're not even appearing before the honorable single judge. They're disputing also aspects.
They're inspired by you. Without appearing in the school for so many years, you're able to get back a job. They say, why should we appear now? Very convenient. I mean, this is quite amazing.
But I have produced all the records before that was considered, your lordship, paragraph 9.
Anyway.
Let them appear at least.
Anyway, we're not inclined. You say the present appeal is directed against the judgment dated 17 July 2019, passed by the learned single judge, allowing writ petition civil 7590 of 2009, filed by respondent number 6 herein, and setting aside an order dated 7th November 2019, passed by the Director Secondary Education in Education Appeal number 10 of 2008, filed by the present appellant. Full stop. By the said order dated 7/11/2009, the Director set aside the termination of the appellant by an order dated 23rd August 2003, passed by the Managing Committee (MC) of the Bhishmagiri Girls High School, Berampur District, Ganjam (respondent number 4 herein). This court has heard submissions of learned counsel to the parties. Paragraph. The brief facts are that the appellant was initially appointed as a class teacher in the aforementioned school, which at that stage was an unaided school, on 30th June 1992, became a permanent teacher with effect from that date by an order dated 30th June 1994. Full stop. It is stated that the appellant worked without any interruption till 12th September 2002. Full stop. From 13th September 2002, the appellant remained absent, and by a letter dated 4th October 2002, and by a letter dated 19th September 2002 of the headmistress of the school, she was asked to furnish an explanation for her absence. When this letter was not replied to, she was asked, another explanation was sought from her. By letter dated 1st November 2002. Full stop. The appellant purportedly submitted a reply to the said letter on 8 November 2002, claiming that she had not received the earlier letter dated 19 September 2002. Full stop. She's supposed to have submitted an application for leave at that stage, which apparently was, open quotation, acknowledged by the headmistress on 16/11/2002 on the body of the said application dated 8/11/2002, unquote. Paragraph. Learned counsel for the appellant repeatedly stressed that this acknowledgement of the receipt of the application from the appellant, the headmistress, would tantamount to sanctioning of the leave by the headmistress, and therefore it could not be said that the appellant's absence was unauthorized. Full stop. This court is unable to agree with the said submission. Full stop. Mere acknowledgement of a leave application would not amount to approval or sanction of the leave. Full stop. These are two different things altogether. Full stop. There is nothing on record placed either before the deputy director second in the aforementioned Education Appeal number 10 of 2008, or before the learned single judge, or even before this court, to show that there was any leave application of the present appellant, which was in fact sanctioned by the MC of the school or the headmistress. Full stop. Paragraph. As it transpires, by another letter dated 26th February 2003, the headmistress again informed the appellant to resume duty 3/2003. Full stop. It is stated that in this letter, the appellant was informed that her leave application had been, single quotes, accepted, unquote. Full stop. However, the fact remains that the appellant did not resume duty by 10/3/2003. Paragraph. The Secretary MC then, by a letter dated 25th May 2003, again asked the appellant to resume duty on the reopening day of the school. Full stop. The appellant did not. Paragraph. When asked about the repeated absence from school by the appellant, despite the above letters, counsel for the appellant volunteered that she had not received those intimations. Full stop. The fact remained, therefore, that from 13 September 2002 till the date of the termination of her services by the MC's resolution dated 18 July 2003, the appellant never reported for duty. Paragraph. The situation was such that the school had to go in for a newspaper publication informing that the appellant stood suspended on 22nd July 2003 and that her services were terminated on 23rd August 2003. Paragraph. It appears that the school became an aided school on 20th February 2004 by a notification under the Odisha Education Act of 1969. Full stop. The writ petition Civil 5022 of 2004 filed by the appellant challenging the termination order was disposed of by this court, permitting her to file an appeal before the Director Secretary Education by an order 20 April 2008. Full stop. Pursuant thereto, the appellant preferred appeal number 10 of 2008 before the Director Secretary Education, which came to be allowed by the order dated 7 November 2009. Paragraph. It was this order that was challenged by respondent number 6, who in the meanwhile had been appointed in place of the appellant in the school. The learned single judge has set aside the impugned order dated 7/11/2009 on two grounds. One was that since the school had become an aided school, the challenge to the termination order ought to have been preferred by the appellant before the State Education Tribunal, bracket ACT. Stop. Nevertheless, on merits, the learned single judge found that the director had erred in allowing the appeal when it was plain that despite repeated opportunities, the appellant had not turned up for duty and remained unauthorizedly absent. Paragraph. And the appellant urged that the MC had never appeared in the appeal or even before the learned single judge to make clear its stand. Full stop. According to him, once the leave application of the appellant stood single quotes accepted, unquote, her absence could not be termed unauthorized. The termination order, according to him, was passed behind her back and was in violation of the principle of natural justice. Full stop. It was therefore rightly set aside by the Director Secondary Education. Paragraph. As noticed by the learned single judge, the appellant did not report for duty despite being repeatedly asked by the headmistress to do so. Full stop. Even assuming that the appellant had belatedly submitted an application on 8/11/2002 for approval of a leave, the fact remained that it was only acknowledged and not approved. Full stop. Later, on 26/2/2003, when the headmistress asked her to report for duty by 10/3/2003, the appellant failed to do so. Full stop. The appellant could not have presumed, having remained absent from 13/9/2002, that she could remain indefinitely absent. Full stop. At some age, she should have asked to report for duty and she should have approached the school. Full stop. Clearly, the appellant did not do that, at least till her services were terminated on 23rd August 2003. Full stop. For a teacher in a school to remain continuously absent from 13 September 2002 for almost a year without ever bothering to report for duty, the conduct is telltale, and therefore the order dated 30th August 2003 by the school MC terminating her services in such circumstances appeared perfectly justified. Paragraph. These circumstances were, as rightly pointed out by the learned single judge, not taken note of by the Director Education, and therefore the learned single judge was justified in setting aside the order dated 7 November 2009 of the Director Secondary Education. Paragraph. No grounds have been made out for interfering with the impugned order of the learned single judge. The writ appeal is dismissed.
Item number 18.
Item number 18 and 19. Well, Your Lordship may kindly come to Annexure 15. That is the impugned order. Annexure 15 at page 62. My Lord has already decided a similar matter. Your Lordship may kindly turn to page 62. Mr. S.D. Rautray, learned counsel for the petitioner, stated that issue involved in this case is analogous to one involved in WPC number 2144 of 2010, which has been disposed of on 25/4/2019. Therefore, in view of the reasons stated in the detailed order dated 25/4/2019, passed in WPC number 2144 of 2010, this repeat stands disposed of in terms of the said order. But that judgment has already been set aside by your lordships.
The impugned order of the single judge has been allowed to potentially violate the Reproduction 4356 of 2007 of the Scotland, relying on an order dated 20 April 2014, 19, in Reproduction 2144 of 2010. That
Next matter is same, only annexure is different. Annexure is 17. Impugned order is at annexure 17.
But the judgment date is 26/10/2021. Read the appeal number 379/49. And that is matter is order dated 22nd July 2019. Petition civil 4356 of 2010, which has to the file of the civil judge in the restoration. The proceedings conflicts. The said petition will now list the directions on 4th January 2023. Appearing for the respondent.
But second matter,
No, they even appearing for the respondent.
that is annexure 17. Impugned order is at annexure 17.
No, anybody appearing for the respondents.
No.
Since this order has been passed in the absence of the respondent bracketed petitioner, the learned single judge will proceed after issuing notice to the petitioner to appear. Meanwhile, counsel for the present appellate will also inform the writ petitioner to remain present before the learned single judge on the aforementioned.
Item number 20.
The next one is the same, right?
Yes.
Same order. Only the numbers will change.
Item 20. Item number 20.
None appears dismissed.
Item number 21.
None appears dismissed.
Item number 22.
The order impugned in this writ appeal appears to be an innocuous order. But leaving aside the innocuity part of the order, this order has a larger impact on the question of administration of the petitioner society. That is why I am challenging this order. If a lordship says the private respondent here is an employee under the society, it's a society on the Society Registration Act. Now it's governed under its own bylaw and Society Registration Act itself. Now he faced an order of termination. That order of termination was challenged before the Honorable Single Judge and the matter is for your lordship. Now, while challenging the order of termination before this Honorable Court, before the Single Judge, what he did is, he submitted a representation to the collector questioning the termination order. Now, after having questioned the termination order by representation to the collector, he again comes forward before this Honorable Court seeking a direction to the collector to dispose of his representation. So in the second writ petition, he conveniently suppresses the earlier writ petition. Conveniently suppresses. My lord, if your lordship sees High Court rules,
Who's appearing for the respondent? Anyone appearing, sir?
Yes, my lord, name of Mr. Biswal is appearing. But that's the reason. High Court rules.
Should we pass it over once? Some Shiba Narayan Vishwal is appearing.
Lord, maybe taken up on some other date, my lord. Maybe tomorrow, day after tomorrow. Passing over, my lord. I am sorry, my lord.
All right. On the first call, none appears for respondent number 3. Although Mr. S.N. Biswal is shown to be appearing on his behalf. The passover is not convenient to Mr. Rathal.
No, let it be passed.
All right.
Let it be passed over. I'm there.
All right, pass.
Pass. I can't be inconvenient to before.
Item number 23.
May I please, Lordship, my lord. Notice has been issued on 6/11/2019 on limitation matter. I have filed the requisites after just 10 days, my lord. May be accepted.
What's the limitation?
I have filed the requisites on 19/11, my lord.
All right. Tell us the matter, sir. Main matter.
Main relating to the power of the sub-register after execution of the register shall deed, my lord. Whether after execution of the register shall deed, this sub-register can make inquiry about the fraud committed during registration of the shall deed and initiate proceeding or not. But the learned
we have filed application for initiation of the proceeding under section 83 of Indian Registration Act. And the sub-registrar did not proceed on my application. I have approached this on court. This on court passed the order. Sub-registrar after registration of the deed became functus officio or he cannot proceed. Functus officio in respect of the cancellation of registration shall deed. But so far as the statutory power regarding initiation of proceeding under section 83 of the Registration Act is not related to cancellation of the deed. He has the power to proceed in the matter.
No, there's a judgment of the Supreme Court referred to, sir.
That judgment relating to cancellation of the deed, where the prayer made to cancel that deed. That judgment is not applicable. That's why
you're not praying for cancellation.
I am not praying for cancellation. I am that person may be proceeded under 1883 of that. Only 10 days in delay in filing requisites. I have filed in 1911.
Was it the delay in filing requisites is condoned? The same requisites be utilized for fresh notice to respondent returnable. 27th February.
Item number 24.
Well, item 24, I have no instruction.
No instructions dismissed.
Item number 25. Item number
None appears for the appellant.
Item 26.
Appellant, sir.
Appellant.
25.
May it please, my lord.
Before my senior begin, I would request for a short passover because my learned senior Sri SP Mishra is on his legs here.
All right. Counsel for the senior counsel for the respondent 3 is stated to be in some difficulty today.
Oblige.
List on, we'll have it some other day. March 22nd.
Oblige.
Item number 6.
Lord, I am for the respondent number 1. I would like to bring the notice of this honorable court, the present position of the case.
Let us find out. 1 minute.
Appellant. Who is for the appellant?
Who's for the appellant, sir?
Appellant.
None appears for the appellant. Dismissal non prosecution.
Item number 27.
What's the matter about, sir?
No, that's regarding UGC scale up pay election. Turn to page 109 of the impugned order, my lord. Relying the judgment of Alok Mishra case, the honorable court matter directing to grant the UGC that has been.
The Alok Mishra.
Yes, madam. That has been stayed before the honorable apex court. So your lordship has in similar cases has issued notice and granted stay.
Yeah, same one.
But there is a defect in this case. I have not taken step for limited
defects be cleared. All right.
Madam.
Same date. There's a date there, no? What's the date? From January 23, no? When is this coming up, sir, next?
In that case, that on 21 September 2022, your lordship has fixed it to after 12 weeks. It has not come, but the matter be pending before the honorable apex court is coming in December, my lord. So your lordship can fix it to January, my lord.
List on. February 27th.
Item number 28.
This petition appellant for your lordship, they succeeded to the property in question, which was settled in the favor of their predecessor by virtue of a vesting case. Since a cloud was created in the title of the appellants, a suit was filed which is pending. Now, during the pendency of the suit, the properties were tried to be put to auction. That was challenged in appeal. Your Lordship, I beg to draw your Lordship's kind attention. And one more thing I beg to point out, so far the civil suit is concerned, the collector, Tahsilar, the authorities are parties to the suit in question. Now, since the property was put to auction, an appeal was preferred, my lord, before the...
He's appearing for respondent 7.
My lord,
I'm for respondent number 7.
All right.
An appeal was preferred, your Lordship. After the appeal was preferred, your Lordship will kindly turn to page 25 of the appeal memo, my lord. Page 25. The appellate authority held that since the civil suit is pending, the auction should be on the basis of finalization of the civil suit. Your Lordship may kindly peruse the last paragraph.
Have you seen the order dated, 1 minute. Have you seen the order dated 29 September 2020? What's his name?
Mr. Das.
Mr. Das. Mr. Mishra. Mr. Sahu, have you seen the order dated 29 September 2020?
Yes, ma'am.
Can we dispose it off? It has to be sent back to the single judge.
Yes, ma'am.
Let it go back. On 29 September 2020, the following order was passed by this court. Learned Counsel for Respondent number 7 agrees that the impugned order of the learned single judge dated 19 September 2019, which was passed on the very first date without notice to anyone, can be set aside, and petition 12943 of 2019 can be restored to the file of the learned single judge for a fresh disposal on merits in accordance with law. In that view of the matter, the impugned order dated 19 September 2019 is set aside, and writ petition civil 12943 of 2019 is restored to the file of the learned single judge, where it will be listed for directions on 1st February 2023. Present respondent number 7, as well as he's the main contesting respondent.
Mine.
Who's the writ petitioner?
And the state is there, my lord. The state authorities are putting it.
No, here are they appearing?
State is there, my lord. My learned senior is appearing.
All right.
Mr. Mahanti was there.
The present appellant and the state will file the respective
we have
replies.
filed a counter affidavit in this appeal. We'll adopt the same in the writ petition.
You file it there, sir.
Yes,
file the replies on or before 2nd January 2023 and rejoinder there to be filed by the writ petitioner before the next date before the learned single judge. No further time will be granted for that purpose. The learned single judge is directed to, requested to dispose of the writ petition as expeditiously as possible. Thereafter, till the disposal of the writ petition, the interim asked with this court. You say status quo shall be maintained by the parties.
Deeply grateful.
Or
grateful, man.
The writ appeal is disposed of thereafter.
Item number 29.
None appears dismissed.
Item number 30.
The Union of India has filed this writ appeal, my lord, selling the order of honorable single judge at page 45, my lord.
220 days delay, sir.
220 days delay, my lord, but your lordship kindly see, the fact remains that there is some office procedure with the delay. Lordship kindly
That
see,
is not accepted by the Supreme Court also, sir.
lordship kindly see, in the stage of fresh admission, this was disposed of. On the stage of fresh admission, this is a quarter eviction matter. Ignoring the guidelines, my lord, that has been disposed of without giving any opportunity of hearing. Lordship may condone the delay on any ground, my lord, on any
There's a
condition.
delay of 220 days in filing the present writ appeal, which has not been properly explained by the Union of India. Full stop. The explanation offered is due to mainly due to administrative reasons, which is not one found acceptable by the Supreme Court in a series of judgments, including that Living Media Postmaster General versus Living Media
Postmaster General, that I
and Beru Lal versus State of Madhya Pradesh. Consequently, the court is not inclined to condone the delay. IA number so-and-so is dismissed. Consequently, the writ appeal is dismissed.
Item 31.
31, Your Lordship may kindly come to the impugned order at page 101.
Lord, before my learned friend begin,
219 days delay, sir.
There is the explanation they are given in the limitation petition, Lordship. Since the matter was of 2009, the client could not be contacted, and immediately thereafter, when he contacted the office, we had filed the present writ appeal, Lordship. The only ground, my lord, on merit, only one thing I'll submit, basing on affidavit filed by the state respondents, the learned single judge has disposed of the matter that I have got the benefits, but fact remains I have not got. Your Lordship, may kindly peruse page 101, Your Lordship, for a moment. 101.
We're not inclined to condone the delays. There's an extraordinary delay of 219 days in filing the present appeal. The only explanation is that open quotation, the office of the advocate of the appellant made at all attempt to inform the appellant, but unquote. And the court is not convinced with the explanation offered. It was for the appellant to have followed up on the matter with the lawyer. Consequently, the court is not inclined to condone the delay. IA number so and so is dismissed. Consequently, the writ appeal is dismissed.
Item 32.
Similar writ petition, writ appeal has been dismissed.
764 days delay. There's a delay of 764 days in filing the writ appeal. The court is not satisfied with the explanation of IA 1094 of 19 is dismissed. Consequently, the writ appeal is dismissed.
Item 33.
None appears dismissed.
Item number 34.
May I please? Mallard's review petition is in file. The review of Mallard's order dated 30/10/2014, passed in WPC number 10435 of 2013. It is at page number 12 of the review petition. Relevant page is page number 14.
See, have you complied with the order dated 2nd December 2014?
Yes, my lord.
How? What's the proof? All right. Now tell us.
My lord, may I read that order?
Right first. At the outset, counsel the petitioner places a memo along with an enclosed document in compliance with the direction issued by this court on 2nd December 2014. Now tell us.
May I read that order, ma'am? The heard Mr. Das, learned counsel for petition on affairs on behalf of the opposite parties, more particularly on behalf of the university. The pleaded case of the petitioner in short is that he had participated in the tender processes initiated by the tender call notice dated 22/2/2011, issued by the office of the Registrar Fakir Mohun University, in short university, for renovation work of canteen of Fakir Mohun University at Noapadi, Baleswar. The documents appended to the writ petition disclosed that the petitioner was entrusted with the said work at the negotiated rate. According to the petitioner, he executed the work in time to the satisfaction of all concerned. In response to the petitioner's claim for release of payment, he was informed by the university by letter dated 11/9/2012, Annexure 7, that the report
was any contempt petition filed?
My lord?
Contempt petition filed?
No, my lord.
There's no stay granted here.
No stay has been granted.
Then why should we interfere?
My lords, if my lords will see my lord's order in the review petition, order dated 2/12/2014.
Even there's no stay.
No, my lords have directed that on being inquired by us, Mr. Patnaik and Senior Counsel has submitted the instruction in any view of the matter for the work done by the opposite party. He is admittedly entitled to an amount of 5,81,653. In this view of the matter, we consider it appropriate
that, and in the interest of justice, to direct the review applicant first to release the payment of the aforesaid amount to opposite party in as a condition precedent to hear the instant petition now.
So there is no stay. There is, he's not filed a contempt. Clearly, he's not going to go in for enforcement. No was made out for review of the order dated. Review petitions dismissed.
Obliged.
Item 35.
May I please, Your Lordship? And let the petitioners associations, and let they have filed the present PIL seeking a direction from this honorable court to the opposite parties for construction establishment of a multipurpose park in Nayapalli, Bhubaneswar, my lord, in ward number more.
Petitioners' representations.
My lord, representations, my lord, were forwarded by the Honorable Governor Secretariat, Chief Minister Office, and the Minister's Office.
Shall be examined. Who has to examine it, sir?
My lord.
Who is to examine? Which opposite party?
My lord, the OP number 1 has to Principal Secretary General Administration Department.
Be examined by the Principal Secretary General Administration Public Grievance Department. And after giving the petitioner hearing, a reason order should be passed.
The petitioner is a senior citizen association. So any
Representative. After giving the
of the senior
representatives of the
citizen
petitioner
because
association a hearing, a reason order should be passed not later than 7th March 2023 and be communicated to the petitioner within a week thereafter.
Obliged, my lord.
The court clarifies it is not expressed in view.
Item 36.
36, may I please? My lord, here petitioners are all inhabitants of village Budhakira, my lord, in the district of Puri. They prayed for this honorable court by way of public interest litigation, my lord, to restore 1,552 acres of Gochar land.
What happened after the order dated? There's an earlier order of 28 January.
My lord.
What happened after that order?
My lord, earlier order is page 19.
So what happened after that?
After that, we have made a representation to the authorities, my lord. Opposite motive number 6, 7, 4, 6, and 7. But till that
No, but we para 8. Just come to page 85. It set out the provision and asked you to invoke the act.
85.
Page 85,
Page 85.
para 8.
My lord, in the fact and circumstances, it is directed that it is open for the petitioner to seek remedies provided for under the act. My lord, this order, they have got water from the, they have been represented to the authorities and they get water, my lord. But now they are opposite party number 9 to 33. They have not allowed to grazing cows, my lord, in Gochar land.
For which you given another representation.
My lord.
The petitioner's representations, bracket annex 11C, shall be examined by the collector, Puri, and after notice to the petitioners and
collector
Puri,
yeah,
as well as opposite parties 9 to 33, and after giving them a hearing, a reasoned order shall be passed not later than 7th March and be communicated to the parties within a week thereafter. Court clarifies it is not expressed in the matter.
Item 37.
In the result application, the petitioner challenged the order of assessment passed under section 42 of the OAT Act under 3 grounds, my lord. First ground is that the audit report has not been submitted within the stipulated period of 7 days from the date of completion of the audit. Second ground is the assessing officer has not allowed 30 days time for production of books of accounts as provided under section 42(2) of the OAT Act in the assessment proceeding. A third ground is that the assessing officer has disallowed my claim of input tax credit for the default committed by the selling dealer.
All can be raised in appeal, sir.
My lord, so far as the 7 days time for non-submission of the audit for the date of completion, it is already covered, my lord. In the case of
Let them examine.
construction, my lord.
In the appeal, they'll examine it factually, sir. Permitting the petitioner to withdraw the present appeal.
My lord, the interim order was there and the revenue was directed to take instruction, my lord, in the issues. That is by the order dated 24/4/2017.
It's okay, sir. There's an appeal provided anyway.
But so far, my lord, this issue is already covered by my lord's judgment.
So you can quote that before the appellate authority, sir.
And so far as this input tax credit is also covered by my lord's judgment.
So quote all
And,
those judgments in the appellate authority, so you'll get.
The appellate court will never deal with all these issues, my lord.
How do you
The
know that?
jurisdictional issue.
Why would they not deal with it?
It is so far as these audit report and this input tax credit and 30 days time, they have never dealt with the
You have to persuade, sir. You are an excellent advocate. You're every day appearing, you're getting so many judgments in your favor.
Yes.
You should use those judgments, cite those judgments before appellate authority, educate them.
In spite of that,
changing law.
And past experience.
And if they don't do that, then you have further remedies.
You are absolutely
there are
right,
so many remedies available to you,
but
sir.
Past experience shows that the past appellate authority never deals with all these issues, my lord.
So we should abolish all those tribunals. Everything only the High Court should do.
Already the issue has been.
Everything we'll do, sir. We'll abolish all those tribunals, all those authorities, all the appellate authorities.
2016, my lord, they have already. The revenue was directed to take instruction in these matters.
All right. Inasmuch as an appeal is provided under the OAT Act, under the against the impugned order dated 10th March 2016, the court is not inclined to interfere at this stage, permitting the petitioner to avail of the appellate remedy in accordance with law. The petition is disposed of, the interim order is vacated.
Delay, my lord, delay to be condoned.
If the appeal is filed not later than 2nd January 2023, accompanied by an application for condonation of delay, citing the pendency of the present petition as the reason for the delay, considered on its merits by the appellate authority.
Original
lectures be returned subject to being substituted by the attested photocopies thereof.
Item 38.
My lord, in item 38, in spite of appellate remedies, my lord, I am before my lord for 4 reasons, my lords. My lord, the impugned order out of the so-called notice was issued on 30th of June 2012. It was never been the portal, never been sought to the appellant, your lordship. I have annexed the portal, the screenshot of portal at annexer 5, your lordships. Can you glance to the page 42, your lordships. This 41, my lord, rather. This so-called notice has never been sought up to petitioner, your lordship. Apart from that, your lordship, the order sheet which is maintained by the assessing authority, your lordships, they also stated that to serve the notice of so-called notice, that is the ASMT, after the order has been passed on 30th of June, your lordships. Apart from the lordship, the petitioner received an amount of 6 lakhs only, your lordships, but the assessment has been made on 22 lakhs, your lordship, on the basis of, your lordship, totally based on the WAMIS data, your lordship. There is no independent application of my lordships. Thirdly, my lord, although I am supposed to be registered under section 73 of the Act, your lordships, they have been assessed me under section 63 of the Act, your lordships. And fourth, my lord, without following the due procedure of law, without donating the REG 12, your lordship, they have assessed me, your lordships.
And we can raise all these points in appeal, sir. Permitting the petitioner to urge all the points raised in the present petition before the appellate authority under the statute in question. The court disposes of the present petition.
I am appealing on the opposite party number 2.
My lord, delay to be controlled, my lord.
If the appeal is filed not later, that same paragraph is the earlier order. All right.
I am appealing on behalf of
My lord, return of Annex 3 series, my lord.
Return of Annex 3 series, subject to substitution with attested photocopies. All right.
Oblige,
Mr. Chimanka's name.
Yes.
Yeah.
Item 39.
My lord, on behalf of Mr.
What is the proof of service of this representation?
Tax matters. Annex of 5, my lord. Page number 30.
What is the proof of service of this representation?
Postal receipt. My
Where
lord.
is that?
Page 30. Page 30. Annex 5, page 30.
Just show her the Annex 5.
दिया है
पछटा जेरक्स करना
এটা দেই দাও
जरा दिया
You've got it in you with you. You've not placed it before us. Ask him to bring it back.
Is that?
I give you.
But with this demand,
Your Lordship,
it has to be challenged in a regular.
it is as regards to GST reimbursement, Your Lordship. Prayer is not against the department, but he has enclosed many summons, many orders, Your Lordship. All those orders have been annexed, Your Lordship.
No, but is this the way to go about it? This representation. Anyway, you see the petitioner's representation, Annex 5. Who has to consider it, sir? Principal Secretary or Commissioner?
No, Your Lordship.
Commissioner cum secretary.
This is
OP number 1.
This is the representation
by the contractor.
It is a contractor and before opposite party number 1.
All right. Department considered by the Commissioner cum Secretary, Department of Rural Works Department, Development. And after notice to the petitioner and giving him a hearing, a reasoned order shall be passed not later than 7th March and be coming petitioner within a week thereafter. The court clarifies it is not expressed in the matter.
Item number 40.
Your Honor, Devasi Satpathy name may be reflected for opposite party number 7 and 8 in item number 39.
All right.
May it please, Millards.
Yes, please.
Millards, the petitioner here, Millards, is a works contractor. During the relevant year 15-16, Millards, he has done work only for government agencies. Millards, your Lordships knows, they are covered under the mega exemption notification of service tax. Now, Millards, what has happened here is 5 different authorities have issued notice for the relevant financial year 15-16 covering the exact amount. Now, Millards, in your Lordship will see page 29. The Paradip Authority issues a notice, page 29, Millards. The Paradip Authority, Millards, superintendent, issues a notice calling for documents. Then, Millards, I'll just show Millards that these are all documents, Millards, he's asking for. Then, Millards, may kindly have, Millards, page 32. A demand cum show cause notice was issued by the Bhubaneswar Authority, Millards. Your Lordship may kindly have the amount at page 32. Your Lordship will see the amount at in second para, Millards, 1 crore 24 for the period 15-16. Your Lordship found it, Millards? For the period 15-16. Then, Millards, at page 42, the Dhenkanal office issues a notice, which is at page 42, asking for, again, Millards will see the first para, financial year 15-16, and asking for several documents. Then, Millards, at page 43, the Angul office, the Angul office of the superintendent, Millards, at page 43, again, ask for same documents. Then, Millards, again, your Lordship will see at page 58, 58, Millards. this is a pre-consultation show cause a consultation prior to the show cause notice, Milords, issued by the Rourkela authority. Now, Milords, there again, your Lordship will see it is for 15-16 is covered, and your Lordship will see my reply that I have given, Milords, which is at page 61. I reply to them saying that there is a show cause notice. These are all the previous authorities who have issued notices. There is a show cause notice by the Bhubaneswar authority, which is at page 61. Your Lordship will see my reply. We intimate that these are all the proceedings going on. Therefore, you are requested to drop the proceedings. We request the Rourkela authority to drop, which is at page 63, my prayer. Because, my lords, other proceedings are going on for same financial year. Despite that, my lord said demand come show cause notice gets issued. Your Lordship will see at page 79 by the Rourkela authority. And your Lordship, what is surprising is the amount is exactly the same as the Bhubaneswar authority. Page 79, your Lordship will see at page 80. At the top, page 80, 1,24,04,583. It's exactly the same amount for financial year 15-16. This demand come show cause notice gets issued.
Yeah, who's appearing?
I am appearing for the
All right, notice. Yes.
my lord. Please, page jurisdiction is page number. And if you see the registration certificate, the service tax number has been allotted by Angul jurisdiction, and that jurisdiction come under Rourkela commissionerate. And if you go for page number 15, if you verify of the writ petition, in case of different show cause notice has been issued on the same issue, answerable to the different jurisdiction authorities, show cause notice involving the same issue shall be adjudicated by the adjudicating authority competent to decide the case involving the highest amount of duty. So it's come under the Rourkela jurisdiction, and Rourkela jurisdiction are doing same correctly, and they are given the opportunity. Of 3 opportunity was also given.
Not just Rourkela, sir. So many, every nook and corner, somebody is issuing notice. And all invoking the same provisions.
The tiebreaker.
Same amount, same year.
I agree with your lordship. And Angul superintendent this come under Angul jurisdiction. At last, Angul jurisdiction have issued the notice to the party.
Whom are you accepting notice for?
Perhaps for all opposite parties.
All opposite.
He accepts notice for the opposite parties. Reply within 8 weeks to join the letter. Till the next date, no coercive steps shall be taken against the petitioner. Let them reply.
CBIC is there, Milord, so perhaps the learned DSG might.
Sorry?
CBIC, so central board is there, perhaps the learned DSG might. No.
Or,
sorry.
15th February.
Grateful.
Item 41.
Your Lordship, petitioner challenging the order annexure 7, page 56, came before your Lordship. Your Lordship, opposite party number 5, as an appellate authority, rejected ITC claim amounting to rupees 63,26,140 only on the ground that this amount is not reflecting in GSTR 28. The petitioner is a central public sector undertaking. There is no dispute regarding genuineness of the transaction. There is no dispute regarding contravention of any provision of section 6.
It is not an appealable order.
It is appealable order, your Lordship, under section 112 of the GST Act, but appellate tribunal is not there.
Same issue. It stated that the appellate tribunal is not yet constituted.
Central state copy has not been solved.
Notice is accepted by Mr. Mishra. Copy, sir. You appear for whom, Mr. Mishra?
Your Lordship, copy is not with me. Your Lordship may
Appears for,
opposite party.
I think it will be 3, 4, and 5.
Your Lordship.
Union of India, Mr. Padi, and State of Orissa, Mr. Malvi. Replies be filed within 4 weeks to join up the next step. Till the next date, no course of steps should be taken.
So only reason is that.
Let's stop. 22nd March.
Item 42.
Your Lordship, there is an IA regarding, this interim relief during the pendency of this raid.
Your Lordship,
We've already dictated it, sir.
Your Lordship, 20%.
Item 42.
May I please, my lords? Sir, may I pray your Lordship, my lords, to take up, my lords, the connected matter, that is WPC number 106 of 2006. In this case, pleadings are complete, my lords. So for the sake of convenience, I pray your Lordship, my lords, to kindly take up the connected matter, my lords.
Lord, I seek permission, Lordship, because this brief was transferred to again to me. So I need 1 day time. Lord, I have filed counter. Earlier I have filed counter, thereafter I, Lord, not in the department now.
Counter in which matter?
Who were you for?
Lord, I am for the GST Central Department. So I
So
need
central excise matter.
Yes, yes.
Huh.
Lord, 1 week time because
At the request of Mr. T.K. Sarpati, the GST department, is it?
yes, Lord.
Central excise. Central excise.
Yes, yes. Before that, there are central excise.
Central-
Lordship says GST. It's,
GST.
Now it's
Seeks and is granted. Seeks an adjournment to get ready the matter. List on 16th March. Interim order to continue.
Item 43.
Lord, 43, your Lordship, last notice has been issued and dated.
No
Lord,
such address, it says.
Yes, Lord, I need, Lord, I've asked for the further address from the department. Lord, I need another opportunity to issue notice.
The notice to the respondent has been returned unserved with the postal endorsement that there is no such address. The correct present address of the respondent should be ascertained and furnished by the department to the registry within 4 weeks. Thereafter, fresh notice returnable. 29th March.
The copy of the same may be handed over for further notice. The copy which is returned, that may be handed over to so that I can use that copy.
No notice.
Item 40.
My lord, a PIL was filed challenging the construction of the development project undertaken by the municipality. Ultimately, initially a stay order, a status quo order was passed.
259 days, sir. There's a
My lord?
delay, inordinate delay of 259 days in filing the review petition. No convincing explanation is forthcoming. Consequently, the MC number 80 of 2012 is dismissed. Review
My lord, that this review has been filed pursuant to the liberty granted by this honorable court. What has happened? The PIL was.
Liberty granted by this.
My lord?
Liberty is granted by this court.
Yes, that is there in my review petition. Your lordship may kindly turn to page Annexure 4, page 17. The PIL was disposed of by vacating the status quo order, and because there was an apparent error on the observation made by this honorable court, a miscase was filed for clarification of that observation. Ultimately, while taking up that, page 17, your lordship may kindly see. Page 17. Pursuant to this order, the review petition has been filed only for clarification. This honorable court directed me to file a review petition if so advised. So after this order, this review petition has been filed. And what was the order passed by this honorable court? Your lordship may kindly see page 13. That is the order under review. Because there seems to be an apparent error on the face of the record. Therefore, without filing review, simply a miscase for clarification of the same order was passed. But by order number 7, this honorable court granted me liberty to file this review. And the
or the relevant portion of the order which is sought to be reviewed, your lordship may kindly see at page 13. Page 13 of the review petition, my lord. A very innocuous prayer has been made because that is contrary to the record in the
what it is, sir.
My lord,
kindly tell us what the matter is.
Matter is the construction of undertaken by the municipality was challenged in a PIL, saying that it is against the wish and the will made by the donor. But ultimately the para 3 of the relevant order, your lordship may kindly see. The PIL was disposed of with certain observation. Your lordship may kindly see the page 14. Having regard to the nature of property, where it is 0.105 decimals, the municipality should also think over the matter as to why they should not modify their resolution, including the plan of construction of the proposed commercial complex, as the same can be exclusively used as dormitory for charitable purpose in the half of the site of the dilapidated chowdhury, and opt for developing the commercial complex in another half of the site of the property in question. By the time this order was passed, my lord, 50% of the construction work was already over. That is there on the record. Therefore, another resolution was adopted by the municipality seeking permission of this honorable court that instead of on the ground floor, the entire first floor will be given for chowdhury purpose. And since more than 50% spending 9 lakhs, more than 9 lakhs have been constructed, the first floor.
Consider it, says. Think over the matter.
The first floor of the building, which is already constructed, my lord, that may be allowed to be constructed.
Nobody stopped anything, sir, here.
My lord?
Nothing has been stopped.
No, that is why, by way of abundant caution, that was also my advice to the municipality. By way of abundant caution, because of this observation, the municipality came with a clarification. No. Nothing has been stopped, and ultimately the status quo order has also been vacated.
Yes. No grounds are made out for review. The review petition is dismissed. All right.
Item number 45.
Not pressed.
Not pressed.
My lord, some direction may be given, my lord. So
not necessary, sir. Right.
Item 46.
The matter is infructuous, your lordship.
Infructuous dismissed. All right.
Item 47.
None of these dismissed.
Item number 48.
None of these dismissed.
Item number 49.
49, the matter has become infructuous.
Infructuous dismissed.
50.
There is
delay.
Yes.
How many days?
More than 700.
I may be excused, lordship. I love 48, your lordship.
1 minute. How many days delay?
702.
There's a delay of 702 days, which is not properly explained. MC is dismissed, consequently review petition is dismissed. Yes, sir. 48.
48, your lordship. I have challenged the order of the learned single judge, wherein there was 2 letters which were never issued by the bank, but the learned single judge did not consider the same and passed the order.
This is the review petition that you filed
against the review appeal, your lordship. That order itself is not a speaking order, your lordship.
Where is the order under review? 23/4/2014. Where is that? Where is the order under review, sir?
My lord, order. Page 10, your lordship.
Page 10 is single judge or division bench?
Division bench. This order was passed by Honorable Justice Court number 9, Justice Sanju Pandey, lordship. Subsequently, appeal was filed. Against the appeal, I filed a review.
So where is the order in the appeal against which you are filing review?
The appeal has been annexed, Your Lordship. The appeal has been annexed.
See itself. There's no, what is wrong with that order?
Lord, the petitioner was a bank employee. Against the order of transfer, he had prepared a lead application. And he managed to obtain 2 documents which were never issued by the bank, Your Lordship. So when he was given the order of transfer, he did not receive it. Subsequently, it was sent by registry post. That also he did not receive. Subsequently, when he filed the lead application, that the bank is not giving him the opportunity to join. Whereas bank has never issued that letter, Lordship.
It's okay. There's no stay of that order, sir. He must be working with you now. He must be working with you.
No, he has retired in the meantime.
Then what is all infractions? No ground made out for this.
He may claim those monetary benefits, Lordship.
Or anyway, that is.
Item 51.
None please dismissed.
Item 52.
No instructions, my lord.
No instructions.
Item 53.
None please dismissed.
Item number 54.
54, no instruction, Lordship.
No instructions dismissed.
Item 55.
None please dismissed.
Item 56.
None please dismissed.
Item number 57.
None please dismissed.
Item 58.
Your Lordship, Your Lordship, this review application have been filed by the department, Your Lordship, challenging against the order passed by Your Lordship dated 9/11/2022. Your Lordship, turn to page 29 of the order. There is a misrepresentation of fact, Your Lordship. For the first date, in the first date, this order has been passed. For that reason, without any record, Your Lordship, I could not controvert the issue. Your Lordship, hence the law has been settled. Your Lordship has settled the law. There is mistake apparent on the face of record, Your Lordship. Your Lordship, so far as Your Lordship may kindly turn to page 29, operative portion, it has page 30, the factual aspect, Your Lordship. At paragraph 4, Your Lordship, he points out that in the present case, there was no opportunity granted to the petitioner to file a reply to the draft audit report. And paradoxically, on the same day, the draft audit report was issued and the final audit report was also issued. Your Lordship, this fact, in a misconception, Your Lordship, there is a mistake on the part of the audit officer, Your Lordship. Inadvertently, that has been written as a draft audit report. In fact, that is the final audit report admitted, Your Lordship. That is the final audit. Entire order.
We have not made a mistake, sir.
Your Lordship, entire order has been passed. Basing on that concept.
It is your mistake, sir. It's not a mistake of the
Lordship. Your Lordship, for that reason, Your Lordship, for that mistake committed by the officer, Your Lordship, the law, Your Lordship.
You will again have to redo it, sir.
Your Lordship, the entire order, Your Lordship, at paragraph 9. Your Lordship, may kindly turn to paragraph 9.
Nothing. No prejudice.
Your Lordship, Your Lordship, at paragraph 9, Your Lordship, in the taxing statute, in the GST statute, Your Lordship, there is no provision.
An opportunity to redo this.
Your Lordship, Your Lordship, that is not, Your Lordship, that is not objected, Your Lordship. Your Lordship, what is here, Your Lordship? Your Lordship, in that paragraph 9 has stated, as directed, that on a plain reading of section 65(4), 65(6) and 104, it is a plain that periodical procedural requirement of having to be given 30 days time to file a reply to the draft audit digit report. Your Lordship, in the statute, there is nowhere that a draft audit report is to be issued to the petitioner. Your Lordship,
issued that.
No, Your Lordship, that has not been. That is the final audit report has been issued. Your Lordship, entire record is with me. Your Lordship, I may be permitted to 5 minutes. Your Lordship, I can convince Your Lordship. Entire procedure as per the statute has been fulfilled. Your Lordship, section 65(4), Your Lordship might have remembered. Section 65(4) says that from the date of commencement of the audit, it has to be completed within a period of 3 months. And section 1014 says that a reply to be given, Your Lordship, I kindly turn to the date chart. I have given a date chart in the review petition at page 13, Your Lordship. The operative portion is at page 13. On 22nd March, Your Lordship, at column number 18, column number 17 and 18, Your Lordship, At 7/7/2022 and 22 March 2022, the petitioner has appeared and filed some of the documents, Your Lordship. And again, he has taken adjournment to file the further document, and accordingly, a date has been fixed to 8/4, Your Lordship. And on 19th/4, Your Lordship, a notice has been issued to appear on 27/4, Your Lordship. So on 31/5/2022, Your Lordship, on telephonically, he has stated that no document can be provided. Hence, Your Lordship, on 31st May, Your Lordship, on the basis of available documents, audit para generated, 7 number of revenue para generated, intimated to the taxpayer by letter number so and so. Here, Your Lordship, 1014 has been complied, Your Lordship. That letter Your Lordship, so far as this case is concerned, Your Lordship, that can be your.
Yeah. It is that the department wrongly termed the document as single quotes draft audit report, whereas in fact it was the final audit report. Paragraph. Having perused the impugned order under review, the court finds that another opportunity is given to the department to rectify the error. Full stop. The order was obviously passed in the peculiar facts as presented to this court by the department. No prejudice is caused to the department with the impugned directions. Consequently, the court finds no ground for review. The review petition is dismissed.
Your Lordship can object my respectful submission. Your Lordship may object. What is the department's, your Lordship, what is the difficulty? Your Lordship, this order may not be a ratio. So far as the order, why Your Lordship? Why Your Lordship?
We have not listened to the dictation, sir. That's the whole problem. We have started.
Your Lordship, Your Lordship, I'm sorry.
Or after lunch.
Yes. Item number 59.
My lord, this TL is pertaining to the
Correct. Let's see
clearing.
what progress has been made. What's the latest, sir?
Please, I have. My lords, pursuant to my lord's last order, my lords had asked us to give suggestion as to flag the concerns which the department is facing and the suggestions which the police department is coming up for expeditious disposal of these vehicles. That's page 3, my lords may see. We have flagged certain suggestions, my lords. We have flagged certain problems which the department is facing. Well, there are two kinds of vehicles. May I state that one is, my lords, vehicles which are seized in relation to a case, and then there are vehicles, my lords, which are abandoned and unclaimed vehicles, which are also, my lords, lying in the Malkhana. So therefore, with regards to page 3, my lords, this is the problems which the department is facing with regard to the seized vehicles in relation to a case.
No, but why do you need court order for this? They have not prevented you from disposing of these vehicles. Is there something in the order which says you cannot dispose of? If
No, my lords, no, my lords. What is happening is, if it is pertaining to a particular case, my lords, then post the trial, my lords, they'll have to wait for the claimant of that particular vehicle.
No, the same procedure. You follow the whole protocol and dispose it off.
Yes, my lords. So, my lords, what is like, my lords, let me read out, my lords, what is the issue, my lords. Because in some cases, my lords, the registered owners of the vehicles are not interested to take zimma of the vehicles which are fully or partly damaged. They do not turn up to the police station despite of repeated reminders. Now, my lords, we'll have to wait for a certain period of time, and after that, my lords.
So what is there in the direction which prevents you from doing that? Let's see that. Is there something in the order which prevents you?
My lords, no. My lords, the point of this affidavit, my lords, is to show that currently, my lords, what is the hurdles that the departments are facing.
So what do you suggest? How do you suggest you overcome the hurdles then?
Yes, my lords. My lords, that my lords will find at page 6, my lords. Please, my lords. If I may read, my lords. If the vehicle is not insured or any defect is found in the registration or engine number or chassis number of the vehicle, the police officer will move the court for orders for disposal of the vehicles. In such situation, the learned courts may be directed to order for auction sale of the vehicles through MSTC portal, a public sector undertaking under Ministry of Steel, Government of India. Second, my lords, in case where the vehicle is not claimed by the accused owner or the insurance company or by a third person, the concerned police officer will move the concerned court with a prayer for auction sale of such vehicle. If the vehicle is insured with the insurance company, the insurance company may be informed by the court to take possession of the vehicle which is not claimed by the owner or the third person. If the insurance company fails to take possession, the vehicles may be sold as per direction of the court. The court would pass such order within a period of 6 months from the date of production of the said vehicle.
There's no problem on these things. Yes.
And then, my lords, there are disposal of vehicles which are, my lords, unclaimed vehicles or abandoned vehicles. For that, my lords, the authority is the executive magistrate.
Okay.
So there we have suggested the third point, my lords, an order for constituting of an auctioning committee comprising of district SP as chairman, one officer of rank of deputy SP and RTO concerned as members may be passed to deal with the matter of auction of unclaimed seized vehicle. The sole function of the committee is to ensure quick disposal of unclaimed vehicles by auction through MSTC portal. After passing of orders of the executive magistrate, the committee shall publish the details of the vehicle so and so along with reference and circumstance of seizure in electronics and print media, fixing a stipulated time and place for auction of the vehicles if no legitimate claimant turn up for the same. These are the measures that. Well, since the last order, Millards, this time, Millards, we have got information from two places, Millards. One is Millards in Bolangir. Millards may see at page 3, page 2, Millards, para 3, Millards. I'll just start with Millards, the top of the page, Millards. 18,014 number of vehicles are still lying for disposal at different police stations. Similarly, out of 3,146 number of unclaimed vehicles are lying at different police stations. 190 vehicles have been disposed of by the court, and rest 2,956 numbers of unclaimed vehicles are still pending at different police stations as on 1/5/2022. Because thereafter, Millards, we have only got information from certain police or certain jurisdictions. Millards, one is Millards from Bolangir district.
But why are you giving 6 months old statistics? I'm not able to understand.
Please, Millards, the mic is from.
All the statistics of parity are 1/5.
Yes, Millards, after that.
31/10.
Yes, Millards, November we had filed an affidavit.
No, this is a November affidavit. This is 22nd November.
Yes, Millards.
Why is statistics being given a first name?
Well, that is probably, Millards, that's a typo, Millards. That's a typographical error.
No. The whole statistics can't change.
Yes, Millards, the last order, my lords may see.
No, I'm saying the whole statistics will change. It's not simply one typo. In two places, you say 1/5. In para 2, third line, you say 1/5.
Yes, Millards.
And the last line also 1/5. It can't be typographical.
Let's post the November affidavit, Millards.
Which November affidavit are you talking of? I'm not able to understand.
I'll show. Sorry, Millards, 11th December 2021 affidavit.
21?
Yes.
We are in 22, sir. The last order was passed.
Yes, 9/9/2022.
99.
Yes, Millards.
So all this we have already recorded in para 2.
Yes, Millards. Millards, see 9/9/2022, Millards, the order that was passed, the vehicle that were there, was post that, Millards, we haven't done that exercise of.
Why not? That's what I'm asking you.
Yes, Millards, only from two jurisdictions we have.
No, the total number of unclaimed vehicles, the figures have not changed. You're just repeating the same thing.
Yes, Millards.
You're saying yes to everything.
No, Millards.
We are not answering the question.
Millards, what I'm saying is post the 9/9/2022, we haven't been able to get, although we have asked for the details, we haven't been able to get the data.
How can you not get? What is this? What are you doing?
Millards, give me 3 weeks time. I will provide the revised data, Millards.
It's unfortunate that in the order dated 22nd, in the affidavit handed over today, which is dated 22nd November 2022, the latest statistics have not been set out. So what has been set out are statistics as of 1st May 2022, which was already taken note of by this court in its previous order dated 19th September 2022. Mr. Manthi, learned additional standing counsel, states that he will positively file another affidavit giving the updated position as on 30th November 2022 on or before 12th December 2022. Paragraph. In this affidavit, certain problems faced by the police in disposal of the old vehicles which are lying at the various police stations. certain suggestions have been set out. Which the court finds to be reasonable. Stop. Therefore, in addition to the directions issued in the judgment dated 31st January 2022, the following further directions are issued. 1. If the vehicle is not insured or any defect is found in the registration or engine number or chassis number of the vehicle, the concerned police officer will move the court. The concerned court, for orders for disposal of the vehicles. Stop the court. The concerned court will, after examining the application, order for auction sale of the said vehicle through the MSTC portal, as it is a public sector undertaking under the Ministry of Steel, Government of India. 2. Where the vehicle is not claimed by the accused or the owner or the insurance company or by a third person, the concerned police officer will move the concerned court for auction sale of the vehicle. Stop. If the insurance company, after being informed by the court, declines to take possession of the vehicle, which remains unclaimed by the owner or a third person, the vehicle will be sold as per the directions of the court. Stop. This application should be disposed of within a period of 6 months from the date of production of the vehicle before the court. Then 3. Vehicle seized by the police in abandoned and unclaimed condition, where the engine number and chassis number is not visible. In such cases, the executive magistrate / SDM will be moved by the concerned IAC to an auction committee will be constituted, comprising the district superintendent of police as chairman, the deputy, one officer of the rank of deputy SP, and the RTO.
May I suggest one thing, my lord? My lord, one advocate also may be.
Not necessary, not necessary, not for these things, sir. 3. The sole function of the above auction committee would be to ensure quick disposal of the unclaimed seized vehicles by auction sale through the MSTC portal. 4. After the EM/SDM passes of the appropriate orders, the auction committee will publish the details of the vehicle, bracket registration number, chassis number, or engine number, or ownership as per RC, whichever is available, bracket, along with the case reference, the circumstance of seizure. Full stop. This details will be published in both the electronic and print media, bracket both Odia and English, fixing a stipulated time and place for auction of the vehicles. In case no legitimate claimant turns up in the meanwhile. Full stop. This F is not necessary. It's something that you will do yourself.
Yes, ma'am.
List on 21st December. Yeah. Which is that? Call it out. No. There are 2 matters. That other matters not come up.
Item 71.
Call it out.
Item 71.
This is that NTPS matter.
Yes, one affidavit I filed.
Item
Substance
71.
of progress.
Plus paragraph 2. 7 kg 010 gram of brown sugar have been destroyed. then 344 quintals and 44 kg ganja were destroyed. And
How many more pending cases are there? That's not clear.
83 cases are lost. That is going on. 30% process is going on.
No. Totally all over Orissa, only 83 cases are pending.
All over Odisha. This by now 83 cases are being pending for certification.
So total number of cases, how many are there in Orissa? And
So I'm
what is the
giving the figure
quantity
of the-
still left to be disposed of?
Plus, I'm giving the figure of the interstate by now, whatever has been done. And plus, then to meet your lordship's query, then again I have filed another affidavit.
In this matter, you say an affidavit has been filed by the Superintendent of Police Special Task Force. Giving details of the disposal of drugs. In the months of October and November. Stop. What is not clear is what is the quantity still left to be disposed of. It is further stated that steps have been taken for certification of correctness of seized drugs in 83 cases. So here again, it's not known how many total cases are pending. Paragraph, Mr. Case that a further affidavit will be filed positively by 12th December 2022. List on 21st, is it?
As I am appearing on behalf of Mr. Mudli, who appears for the
So on 21st December plus. 21st December. Okay. Item number 60. Item 60.
Petitioner before your lordship, in second round of litigation, they approached the Salon Court, and the Salon Court directed to approach the appropriate forum. And accordingly, petitioner filed the case before the appropriate forum. Lordship may kindly come to page 73 of.
Why is this a PIL?
My lord, PIL.
What a PIL?
My lord, because your lordship may kindly come to page 73. Internal page 10. Peruse the report on dated 28/2/2019, submitted by Assistant Settlement Officer Recording Kotak. The asset on there, the corresponding Sabi Khata plot number 401, part under Sabi Khata 240 of Onabadi Khata and Sabi Kisam Sala Jungle, collected from the others 1485, Janmandi number 694 in Khata number so area so. My lord, may kindly come to page 67. It is in the year 1930 settlement, the land was recorded as Onabadi and Kisam was Sala Jungle. Thereafter,
if you want to challenge the order of the commissioner,
yes, my lord.
Don't do it in a PIL, sir.
Yes, my lord.
The affected parties will file the
Impugned order is the order passed in the revision petition. That is not the PIL.
Not a remedy. Correct.
My lord, earlier there is a PIL before this one will go.
Maybe. That is for all the statutory processes.
No.
By virtue of that PIL order,
all the statutory orders passed.
statutory orders were passed.
So
that is to be challenged before the appropriate
authority.
No, my lord. Your lordship may kindly appreciate your lordship may kindly come to page 67. The order passed by the.
My lord, actually, this case may not be dismissed. It will be placed before the single judge, because revision petition order is to be challenged in writ petition, but before the appropriate bench.
No, by the aggrieved party.
No,
Yes.
aggrieved party is the villagers. They are aggrieved because the land was recorded in 1930
The
settlement.
present petition which questions
as Sala Jungle.
the order dated 2022 passed by the commissioner, land records and settlement in RP number 769 of 2022 cannot any longer be considered as a public interest litigation. Full stop.
769 of 2017.
Yeah. This is despite the fact that the impugned order may have been passed by virtue of earlier directions issued by this court in a writ petition which was treated as a PIL paragraph. With the statutory authority having passed the order in a revision petition, the present writ petition shall be listed before the roster bench of the learned single judge as a non-PIL writ petition and will be dealt with in accordance with law. The matter be listed before the roster bench on 2nd January.
Item number 61.
May I please your lordship? My lord, this is PIL has been filed on the ground that the Cuttack municipality was one of the oldest municipality in the state, my lord. Now the Cuttack municipality is going to sanitary system of the Cuttack city is going to hand over the sanitary system of the Cuttack city to the private organization. So on that ground, if the municipality, the sanitary system of the municipality will hand over to privatized agency, then the mehantar, who are the manual scavenger, are losing their livelihood. So on that ground, they made an application before the government, my lord. That has been filed annexure, my lord. That is annexure 4, my lord.
All right. That is, representation at annexure 4 shall be examined. Why by the chief secretary, sir? Secretary
lord,
Urban Development can examine by the Secretary Urban Development. And after giving the petitioner a hearing, a reasoned order should be passed thereon not later than 7th March. And we communicate to the petitioner within a week thereafter.
My lord, giving opportunity of the petition. My lord, oblige me.
Item 62.
May I please your lordship? No instruction.
No instructions dismissed. All right.
Item 63.
During pending this writ petition, the petitioner has died. So substitution petition IA has been filed.
That IA is allowed. Okay. What's the matter about?
So
IA is allowed. The reason stated there.
The challenge the assessment order.
You can challenge it in an appeal, sir.
Last because in interim order I have directed to deposit 25 lakhs. Subject to I have deposited.
That will continue then during the pendency of the appeal. You see the counsel of the petitioner seeks
so then my lord,
present petition.
May be allowed to adjust the 10% of the and balance to because I have deposited 30% of the tax.
It's all right, sir. Let that remain. You see, counsel of the petitioner seeks to petition liberty to challenge the impugned assessment order in accordance with law in an appeal as provided by the statute. If such appeal is filed not later than 2nd January 2023, accompanied with an application for continuation of delay, citing the pendency of the present petition as the reason for the delay, it will be considered on merits by the appellate authority. The court clarifies that it is not expressed anywhere in the matter. The deposit made by the petitioner pursuant to the order dated 21st March 2017 will continue during the pendency of the appeal, and in view thereof, no coercive steps will be taken against the petitioner as long as the appeal is pending.
So that will be treated as a pre-deposit, my lord.
The said deposit also be accounted for the pre-deposit amount to be deposited for the entertainment of the appeal. Full stop. The annexures be returned, original annexures be returned, subject to being substituted by attested photocopies thereof.
Item 64.
Please, Millards, the limited issue in this, Millards, is that I applied for certified copies of the order sheet and the search warrant and I was rejected. Millards, this is a case arising out of a search proceeding. Show cause notice have been issued. So, Millards, the issuance of the show cause notice, Millards, marks closure of investigation. Now it goes into the phase of adjudication. At this stage, they reject it, which your lordship will find my application at page 64, your lordships. This is what I asked for at 64. Certified copy of the search warrant, which was shown at the time of search to the designer. I'm an architect company. So the designer who was there employed with us, my employee, it was shown to him. And that search warrant, I want a certified copy of that search warrant, which was shown to be, and the order sheet, point number 2.
But why will you not give them search warrant copies?
Space not 66. No.
It has
Not
been
the-
rejected saying that
It is because the
No,
investigation.
no, this is the searched person. It's not some public. He's not asking it for public display. He has been searched. He's asking for search warrant. He's not some third party.
No, he's not seeking for the order sheet.
Yes.
It is not in somebody else's case,
No,
sir,
Lord,
in his
my-
own case.
Lord, my instruction is, Lord, I have talked to the Lord investigation officer. Lord, it is investigation by the DGCI, Lord. Lord, here the investigation not yet been completed.
So what? He
So Lord, there are some input, Lord, where from you are get the information that
He's
has
not,
been
he's
let
not
us
asking
late.
for that.
He's asking for an order sheet, Lord.
Order sheet. In the order sheet, where are you noting who's from where you got information? You're not.
Lord, say, let it come next week, Lord. I'm taking
Mr. Satpathy, notice, Mr. Satpathy, notice for the respondents and seeks time for instructions. List on 15 December.
Let's say interim.
Between now and 15th, what is going to happen?
Adjudication process
No,
is
that
going
is-
on. Why? Because I say investigation is complete. Only when investigation gets complete.
Between now and 15th, they'll adjudicate. You then will file a writ petition. If they adjudicate despite this writ
Very well,
petition,
very well,
you
very
have a
well.
very strong ground, sir. Right.
Let it come on 15. Great.
Item 65.
May I please your lordship?
Yes.
I'm appearing for Mrs. Kanbala Roy Chaudhary for item number 65 and 66. Your lordship may kindly grant a 1 week time to rectify
Okay,
the
defects be removed within a week. List thereafter. Right.
I am preparing 66 minutes. I will file the Vakalatama in the course of the day for the department minutes.
All right.
66 minutes.
All right.
Oblige.
Item 67.
May it please your lordships. My lords, this is a very unique case. After going through the papers, my lords, I really thank the commissioner of, that he is working till midnight. My lords will kindly see. Notice under section 148A, small b was issued by the annexer 2 at page 12
on 23rd March.
On 23rd. I received it on 26th, my lords, 26th of March.
And you have to file a reply by 30th.
And I have to file. And the order, lordship will kindly see. The 148AD,
is passed.
The order was passed
in 4 days.
In the midnight, digitally signed by the commissioner at 11:20. And that is my specific abhorrement. I have also enclosed the, so as to avoid the limitation. Because 6 years, 149, that no notice shall be issued. And I am supported by a division bench of the Allahabad High Court.
No, but the same question, sir.
Yes.
That batch.
Batch case, your lords.
No, not the same question, my lords.
Why not?
Here, my lords, less than 7 days time was given.
That's all right, sir. The question really is, do we entertain a challenge to 148D in writ petitions? That's all. As simple as that. Punjab and Haryana High Court says, no, not at this stage. We don't want to interfere, and that has been approved by the Supreme Court.
My lords, lordship is again.
That is the batch.
No, my
You have
lords.
to wait for half an hour more.
No, I am ready to wait for 1 hour. With great respect, my lords. Punjab and Haryana High Court.
No, we'll hear that argument. The whole court
No,
is waiting for that.
here, my lords. Lordship will kindly agree. One thing, that the mandatory requirement under section 148AB.
Even if we agree that agreement is valid only for half an hour. Because the agreement is valid only for half an hour. After half an hour, we may disagree.
That means lordship before trial, my lords.
That's why I'm saying it's better you keep the powder dry. At 3 o'clock, you can fire.
No, my lords. I am ready to wait. That is not the, my lords. Lordship will say, I will see it up to 5 o'clock. That is not the, but the question is, my lords, Punjab and Haryana, what was...
we won't decide this. What I'm saying is we'll just take it with that batch. The same matter.
My lords.
We'll just take it with that batch. We're not disposing it off.
No.
So we'll take it with that batch.
Yes, my lords.
Right.
Item 69.
169. 68 is the lordship. 68
Sorry.
is the review petition.
I'm sorry. 68. 68.
item 68 is a lordship similar to yesterday's item 75. It is petition number 109 of 2014, your lordship. It's been disposed of the same.
Same meaning what? What did we do?
I have already yesterday. Item 75, 76.
Your lordship has disposed of the petition, giving liberty to the petitioner. If they take any other coercive action, I can again oppose this honorable court.
I see. What's the order passed? We haven't uploaded it yet. So same as yesterday's?
Item 75, your lordship.
Okay. What is item 75 yesterday? All right. Same order.
Great.
Item 69.
69, Your Lordship, I have solved copy yesterday, but I have to solve the copy before that. But inadvertently, I have solved the copy to the other layers. But yesterday, I have solved the copy to Mr. Acharya.
All right. It is stated that copies of the appeal memo been served on counsel for the respondent only yesterday. So list on 14 March.
That's 70 also, Milots. I'll need to seek instructions in that.
In 70 at the request of counsel for the respondent, list on same date, 14 March.
Milots, one more submission, if I may make.
Yes, please.
With Milots, pardon me for Milots, item 64. My learned senior is there. Can it be 14th instead of 15th, Milots?
All right, 14. All right.
I'm so grateful. I'm so grateful.
Item number 72.
As item 72, the suo motu petition, Millets, subsequent to the decisions of the Honorable Supreme Court with regard to the
Pursuant to your lordship's order dated 8/9/22, I have received
coal-fired thermal power plants.
The health benefits.
The large part of your lordship's order, state was to file an affidavit.
Yes, I have filed an affidavit today.
I have received a copy.
Filed yesterday. I've served copy.
Copies may be served.
I'm yet to receive copy.
There are about 70 odd respondents. So what I suggest is, my lords, if they
The
can.
state's affidavit has been filed today, is it?
It was filed yesterday. That's soft copy. Soft.
Why you call it a preliminary counter affidavit?
Well, it's because my lords had given certain directions. As this is the first steps that we have taken, my lords, and then
All right. An affidavit dated 22nd November 2022 has been handed over by counsel for the state in court. He states copies thereof will be served on all the counsel for the parties.
We'll serve soft copies on the parties.
Whatever.
Yes. But your lordships had given liberty to us to file affidavit. We are filing affidavit.
All right.
I'm appearing for 20.
20, is it?
There are a lot of respondents. I'm respondent 20. Lordship had given liberty in the last occasion
All
to
right.
file affidavit.
I need a
The
copy.
affidavit of respondent number 20 is also taken on record.
I let him serve a copy on me also because
Copies thereof is served on counsel for the other parties.
Grateful, sir.
I am for the minor, so opposite partner 6. Let a copy be served on me.
Everybody.
I am for the Tata Sponge Iron Limited.
All right. March.
Item number 73. Item 73.
Mail ID or mail ID mail
That is a 2014 affidavit, sir. It asked for an filed by your order dated 23rd August. No affidavit appears to be filed pursuant to the order dated 23rd August 2022. Copy of that order, together with today's order, will be delivered by special messenger to the registrar of the Ravenshaw University, requiring immediate compliance with the order dated 23rd August 2022. List on 3rd January.
Item 74.
May please, Your Lordships. This is an application in form of a PIL, Your Lordship, wherein the petitioner is approached seeking a direction to declare the sand quarry under Jamuni Gram Panchayat as not a Sariyat source, Your Lordship.
Are you appearing for the first time or you've been appearing?
This is a transfer brief, Your Lordship. Last
that's what I
occasion
thought.
also. Yeah.
All right.
Last occasion, Your Lordships have asked for a status report, Your Lordship.
Correct.
My lord, this is that PIL in which your lordship has seen the video also that the road condition is bad, and that is why your lordship is not inclined to vacate the interim order. And in that case, the development is that this Sarat source was settled in favor of opposite part number 6, for whom Mr. Naik is appearing. And in the meanwhile, that agreement is also cancelled by order of the court. So there is no lessee as of now, as on today. So, and the complaint is that the road is not functioning. The sarpanch is before your lordship, and your lordship may suggest one thing, subject to your lordship's appreciation. If your lordship may direct that if the collector will conduct the village committee meeting, if it is the village committee will agree, and if the sarpanch will agree, then we will allow the Sarat to be operated. Subject to the agreement of the village committee, and only Sabha will be taken, because there, as of now, there is no lease in favor of anybody. Now, see, the petitioner wants that it should be declared as it will not be that it is not a Sarat source because of all this.
The embankment is unsafe, Your Lordship.
Yes, all these things will be raised in the police.
It's in a very deteriorated condition, Your Lordship. So when the sand trucks will ply over those roads, and the roads are very narrow also, that may cause, that will be dangerous to the villagers and also to the agricultural lands, because there is no source of communication to the source. And the sarpanch himself is the petitioner here, along with some other villagers.
But does the state want to still go ahead with the Sarat source?
No. As on date, the Sarat source was settled in favor of the.
Oh, that's been cancelled. I'm saying, are you planning to again auction it?
No, re-auction has not been. Yes, that is my instruction.
So if you decide to re-auction, then you consult the Pali Sabha then.
That is what I'm saying. That is what I'm saying.
Yeah, let them consult you before they take any step.
In accordance with the Pali Sabha will be conducted by the district administration. If there is a consensus and if the road condition are all are in viable condition, then only we will re-auction or settle the Sarat source in favor of anybody.
Lordship, I would pray that let the Pali Sabha be consulted. I don't dispute for that. But steps may be taken.
If it happens, then we'll keep your challenge alive. At that stage, you challenge. If they decide after the Pali Sabha to go ahead, then you can challenge it at that stage.
That liberty can be granted. Yes. My lord, we will conduct the Pali Sabha in case we intend to settle the Sarat source in favor of any person. He is already out. The client of Mr.
You say Mr. Manthi informs the court that the lease in favor of respondent 6 already stands cancelled. And as of
my
now,
lord, Mr. Naik is also appearing. He's
Lordship, in the meantime, cancelled, and I filed a review application, my lord, there before the collector, my lord. That's pending. That's pending, my lord. That's the instruction. Yes.
Collector will review his own order. That is the what I have no instruction to. He might have asked for review of the, but collector has cancelled it because that is also by order of the
under review, my lord.
By order of
against this order, the review petition is in file. That's my instruction.
By order of the Honorable High Court, the collector has cancelled because he has submitted false affidavit before at the time of submission of tender. The review will be decided on its own merit, but as on today, there is no lease in favor of anybody in respect of this particular Sansara.
All right, stands cancelled. Counsel for response number 6, however, states that he has filed a review petition for the collector. Paragraph B, that is, it may, as of date, the Sans Sairat in question is not operational. Mr. Manti makes a further statement that in the event any move is made for a fresh auction, it will not be
My lord,
undertaken.
your lordship, for fresh auction or for settlement of this, because what he is saying, if the collector decides to review
Or
it
for settlement of the Sairat source, then
in favor of anybody,
it will be done only after consulting the Pali Sabha
and subject to the road condition.
and subject to the road condition. Full stop. The court clarifies that the right of the present petitioners to question the decision to go in for settlement or auction of a Sans Sairat in future is kept open.
My lord, what your lordship has said?
The right of them to challenge the decision to go in for a fresh auction or settlement of the Sans Sairat is left open as said.
My lord, we will conduct Pali Sabha and consult the petitioner,
Yes.
villagers.
Yes.
Yes, Your Lordship.
The petition is disposed of in the above terms. Right.
Obliged.
Item 75.
My lord, on behalf of Mr. Mishra, I pray for an adjournment on the ground that he is undergoing a treatment of the eye, the laser treatment.
All right. Mr. Mishra is stated to be unwell. List on
Your lordship will fix a date, my lords.
29th March.
Obliged, my lord.
Item 76.
Please, my lord. Lord, grievance of the petitioner is to the order at annexure 1, my lords. Petitioner before your lordship is a retired educationist, and this is in the nature of a PIL, my lords, relating to the order of the government at page 17, appointing Subuddhi as president of the governing body of Cuttack College, Vidyadharpur, and one Sarda Mahapatra as president of the governing body of the City College, Cuttack. Lords may look at annexure 2, which is the relevant rules.
This will take some time, I think.
Take a little bit of time, not
We
much.
only have counter of opposite party number 1.
The others, my
The
lords, they have not filed.
private opposite parties
They have not.
file करछन्ति.
You have to file a reply. Last opportunity is granted to opposite party number.
I am for opposite party number 8.
I am for 6, lordship.
All right. Opposite parties 6 to 8 to file the respective affidavits within 4 weeks. It is made clear no further time will be granted for this purpose. Rejoinder thereto if any before the next date. List on. January 27th.
27th January.
Right.
Can it be in the first week of February?
All right. 2nd February.
Lords, in the meanwhile, I have filed an IA 15911 of 2022. That's at flag B. Lords, can the state produce the relevant records?
Yeah. 15911 2022. A direction is issued to the state to keep all the relevant records ready for perusal on the next date. The application is disposed.
Item 77.
Lordship, on the last occasion, your Lordship has allowed the amendment and directed me to file the counter, your Lordship. Lordship, 4 weeks more time may be required for filing.
Final opportunity to the state to file its reply within 4 weeks.
Interim order may
be interim order to country.
Much obliged.
6th March.
Item 78.
May I please, your lords? Well, this is a covered matter, in fact, my lord. My lord senior had on the last occasion, my lord senior had taken time to examine whether it is covered. My lord, the grievance here is, my lord, the petitioner is a lecturer of Utkal University, my lord. And he has been given allotted quarter, my lord, accommodation for which he is paying the rent as per the standard of rate prescribed by the state government, my lord. My lord, in that
he's no longer lecturer, sir.
My lord,
is he still a lecturer?
No, he has already retired. But the thing is, my lord, since 2005, the tax on the head of accommodation is being deducted from his salary, and he has paid, my lord, lakhs of rupees towards that. My lord, I am entitled to get refund of that, my lord. My lord, your lordship knows, my lord, in the case of Arun Das and others versus of India reported in, my lord, 2000. Copy to move. I'm just supplying the copy. It is reported in 2006, 286 ITR, page 89. The Honorable Apex Court, my lord, and on the basis of that, if your lordship comes to Annexure 1, my lord, in the writ application, all other universities, they have, my lord, your lordship will find page 14 of the brief, man.
1 minute. You're aware of this decision?
Last occasion,
Mr. Chimanka, are you aware of this decision?
Mr. Chimanka.
Yes, Will.
This is perquisite.
Perquisite.
You are aware of this ratio which is laid down by the Honorable Apex Court? Arun Kumar.
Yes, Arun Kumar case.
2006.
Remember or guess properly, there has been an amendment. Right now, I'm unable to.
2001 amendment.
Yes, that has been that rule 6 of the. There has been an amendment. I'm not sure about it, but if I remember properly.
Let me check.
All right. Counsel, the petitioner relies on the judgment of the Supreme Court in Arun Kumar versus Union of India, 2006 286 ITR 89 bracket SC. State that the concessional rent charged from the petitioner for the official accommodation is not a perquisite, right? And is therefore not taxable. And therefore, in respect thereof, no tax could have been deducted at source. Mr. Chimanka, learned standing counsel, seeks time to examine the judgment and make submissions.
Seventeen 2.
16th March.
Rule 3.
Item 79.
This might be improved.
79.
Is appearing.
Might be infectious this matter. Because this.
Sir, are you appearing in 79? Look at that. Nas dismiss for opposition.
Item number 80.
Yes, my lord, in item number 80, and for the petitioner, my lord, in this case, the petitioner challenges
Annex 1, that is order dated 2/3/2017, passed by the opposite party number 2 for the period of 2004 to 5, extensively exercising the power of Orissa Sales Tax Act, my lord. Thereafter, against that order, I had appeared before the appellate tribunal, that is in first appeal, and against first appeal order, I appeared before the Orissa Sales Tax Tribunal in a second appeal. Second appeal has already been disposed of, where my plight has been decided, and that second appeal has not yet been challenged since 2006.
This is that sources matter, your lordship, pre-computation, your lordship. And in this matter, department has not gone to Supreme Court, your lordship. This petitioner is not in that batch. So, your lordship, this Neelam motor,
yes,
your lordship has already clarified in that Bajaj Auto second case, your lordship.
Correct.
In those matters where.
So the recomputation orders go.
Yes, ma'am.
All right. In view of the judgment of this court, dated 20 August 2021, in Reproduction Civil 14486 of 2021, bracket Neelam Motors versus Deputy Commissioner of Sales Tax. The impugned order dated 23rd December 2009 of the tribunal, and the recomputation orders, bracket Annexes 2 and 3, are hereby set aside. The writ petition is disposed of in that purpose. All right.
Item 81. So item 81 belongs, the lead matter is belongs the Orissa Railway Taxes matter belongs WPC 12779 of 2017. So that is not in my lordship's board belongs. The lordship admitted the matter and framed questions belongs. The issue involved is whether section 49(2) can be invoked by revenue to seek extension of belongs time. This is the anti-tax matter, and the lead matter is evaluated tax bills. That you will kindly call this matter along with that.
List along with, here notice has gone or not gone?
Notice has gone.
List along with 12779 of 2017. Which date is it? No date fixed.
Sorry?
No date has been fixed in this.
No date has been fixed. They have not filed counter.
On 28th March. All right.
28th March.
28th March.
Item 82.
82, 4 weeks time.
Reply be filed within 4 weeks.
82 and 84.
Interim orders are there.
Yeah, let's see.
84.
Both the cases, 4 weeks time.
84. So 84 bills, my lord, see the noting. There's opposite party number 4 is the sole private opposite party, necessary party bills. Your lordship have issued notice, I have filed requisites. The AD is not back. Your lordship may kindly call for tracking report so that further directions can be made.
In which 84?
84 bills.
In 82, you say counsel for the state seeks 4 more weeks time. File a reply, rejoinder be filed before the next date. Interim order to continue. 84. This Mr. Nayak appears for them all this time. No? Respond before. I think we serve it on Mr. Nayak who appears for them.
For Vedant Aluminum.
Vedanta.
He was there, in fact, just now.
Yes, I will serve a copy on him.
Mr. Sahu states that the copy of the petition will be served on Mr. Nayak, who usually appears for respond before. Opposite party number 4.
Interim order to continue.
Interim order to continue. Both matters you see list on 28 March. PK Nayak, Mr. PK Nayak. All right.
Item 83.
86 minutes.
83.
Oh, I'm sorry.
83 on behalf of Mr. S.K. Jena, prefer on time. On behalf of Mr. S.K. Jena, who is out of station, 1 week time.
You want to file rejoinder or not?
Rejoinder will be filed. Will not filed.
Rejoinder will be filed before the next date. Interim order 28 March.
28. Item 86.
This writ application on my prayer is to allow me to deposit the amount of tax which has been determined by the authorities as per the Sabukka Biswas scheme laws in SVL DRS 3 laws. And your lordships have dealt with similar matters. May I just humbly pray your lordship may kindly permit me to place those matters. Subject to your lordship's kind consideration, lords.
Notice has already been issued. What is your
notice
response?
has been issued.
Lord, I have asked for instruction, no instruction has yet been received. So your lordship may.
So here, my lord, subject to your lordship's kind consideration, the payment amount and this rectified form would be there. And instead of technical glitches in paragraph 2, my lords, my specific case is because of this COVID-19 problems, my lord, I could not pay this amount of rupees 5,76,000 and 36 lakhs.
Is that the same thing as COVID?
Sorry, my lords?
Is it the same thing as the COVID? I mean, as technical glitch.
No, instead of technical glitch, it should be because of COVID and other reasons. And this amount in the first paragraph, second line, the amount in my lord is 56. It's at page 16 of my prayer, my lords. And the forms are at page 77 and 81. (81), 77 and 81. Detach. Central Board of Indirect Taxes and Customs.
On or before 31st December.
No, it's your lordship may extend the time of 9th of November to
31st December.
31st December.
As per the
And this
calculation.
payment sum is changed.
Sorry,
The payment.
It is 36 lakhs.
it's my lord, one is 5,76,370 for the period. No, that's at my prayer at page 16, my lords. For the period 1/4/2016 to 1/6/2017, and 36,63,126 for the period 1/4/2012 to 31/3/2016, my lords.
Two amounts.
That is, my lord, those.
Prayer.
Sorry, my lord, that is in the prayer. That is in the prayer, my lord. And the corresponding form 3 is at page 77 and 81 of your lordship brief, my lords. If I don't Central Board of Direct Taxes or what? Central Board of Direct Taxes.
No, indirect tax. We change it like this. Out of the code could not be made.
And this SVRDL 3 rectified word should be omitted, my lord. It's not rectified words. In the first paragraph, third line, my lords.
The lordship may say this time of the scheme has already been over.
Your lordships have dealt with that matter.
Yes, that,
and as per the,
I'm not obstructing. I'm not obstructing.
And as per their own circular in another case of mine, your lordship
that is what I'm pointing, and that is what I'm pointing.
Manually, they have also permitted, Lord. And following that observation may be also them, Lord.
Your lordship that observe that it should be manually accepted. Otherwise, my lord.
The order already says that.
Yes.
Item 87.
In accordance with law, your lordship have said no, with respect.
Whatever is there in that order.
Manually, lordship may add one word.
It's there in that order, I think. The last line.
My lords. I'm sorry.
Item 87.
My lord, I may be pleased. My lord, I am in the BC mode. Lordship, at the mind prayer is that the amount which is being charged for the cancellation period of my registration, license registration.
You wanted to seek instructions last time.
No, Your Lordship, he is claiming that the interest and penalty should not be imposed. My Lord, this Honorable Court has already passed a judgment. My Lord, Justice Singh and Justice Rahman, paragraph 13, Your Lordship kindly against cannot be a statutory payment of interest and penalty. RC has already been restored by virtue of the appellate authority order. He is now claiming that so far as the payment of interest for non-filing of return and the penalty as enacted by the law, it should be deleted.
Well, Lordship, I don't have any dues on that period.
You want to file a reply, you file, sir. Mr. Satpathy states that he'll file his reply within 4 weeks, rejoinder for the next date. 28th March.
88.
This matter, my lord, stands covered by a lordship's judgment in Newton. Lordship may kindly turn to Annexure 5 at page 85 minutes. Annexure 5 at page 85 minutes. So assessment year is 13-14 and the issue date, my lord, is beyond 6 years. It's 31/3/21. The exact case.
Mr. Mahapatra. Is it covered?
I've given a copy to my learned friend also.
Sorry, madam. I've gone through that is covering.
Covered. Same order. In view of the order passed with this court on 6th May 2022 in Nutan Bhushan Jaina versus Principal Commissioner of Income Tax, Reputation Civil 11181 of 2022. The imbue notice dated 31st March 2021 under section 148 of the Income Tax Act for assessment year 2013-14 and the consequential reassessment order bracket Annexure 6 and demand notice bracket Annexure 7 are hereby quashed.
This is also a non-existent unit entity, my lords. It's already merged with Utkal Gramin Bank.
Oh, I see.
If your lordship can add a word also,
that's all right.
Item 89.
Obliged, my lords.
Permitted to withdraw, your lordship.
Dismiss this withdraw. All right.
Item 90. 89. Item number 90.
My lord, item number 90, I pray let it come with the connected matter WPC number 20484 of 2022.
It has become infructuous.
No, my lord. It has not become infructuous.
22. It has become infructuous.
I pray let it come with the connected. It has not become infructuous, my lord.
When is it listed?
My lord, it is for the fresh admission 20484. It has not been listed.
Okay, list along with 20484 of 2022 on 6th December.
Item 91.
My lord, in item number 91, state has filed a counter, my lord. I need some time to file the rejoinder.
All right. Rejoinder be filed for the next date. There an interim order?
No, yes, yes, my lord, interim order is there.
Interim order to continue. 14th March.
Lordship is fixing to 14 March.
14th March. Pastor matter item number 16.
After due selection, he was joined as a junior assistant on 23/5/2017 before the opposition one. While he was continuing without any proceeding, without any so cause, without any draftage, without following the principle of natural justice, the termination order issued by the Annexure 6 on 2/8/2019 after 2 years. On the as per Rule 5(1) of the Central Service temporary service rules, he is a regular servant, but as per the temporary service rules, the termination order issued without any proceeding, without any so cause, without any draft charges. And against that order, I have filed a writ application, and the Honorable Single Judge has passed the order, but has not passed any interim order, my lords. Therefore, I have filed the writ appeal, and the writ appeal, this Honorable Court has protected. and I am continuing, my lords. See, annexed 7, the Honorable Court has only issued this in the writ application, not passed any temporary interim order. My lord, simple, I paid my lord direct to the Honorable Single Judge, they have the disposal of the writ application. Till then, the interim order will continue.
Yes, sir. Writ petition is pending.
Yes, writ petition is pending.
Declining to grant stay. Already second August 2019, terminating the services. And civil judge, the roster bench on 4th January 2023. Are pleadings complete with the information?
In the writ petition, pleadings are complete.
They have not filed the counter. There's a filed counter in the writ appeal, but counter is not filed in the writ petition.
19th December 20. This is the appeal file is adjourned in court. So for the time we have
Item 22.
The interim order will continue till then.
Item number 22, Pastor.
My lord, item number 22, I pray for an adjournment, my lord. I'm on behalf of Mr. Rath, my lord.
Mr. The learned counsel, the appellant stated been some difficulty today. Interim order to continue. List on 20th March. Yeah. I'm going to ask for a accommodation.
So, right, I felt that your lordship is sneaky.
The cold is getting worse. So
Yes.
So your lordship needs rest.
That's what. So we'll have it next week.
Next Wednesday, my lords.
All right, next Wednesday.
My lords, may I pray the interim orders to continue?
Yeah, interim orders.
I was talking to my friend that my lord Chief Justice is sneaky.
So we are marking.
But I have a very humble.
Your lordship is visibility.
Your lordship, actually, I was expected so, but
I just have a humble prayer, subject to your lordship's kind lords. There are interim orders in all cases.
Correct.
Except in WPC Law 22817 or 22. So that order may be there at least till Wednesday.
Or
Some
in
interest.
all matters, or in
Millards,
the
this
new matter of
228.
Yes,
you say notice.
new matter.
Notice.
Notice and stay, man.
No, Lord.
Yes, stay. Sir. It's not, in all the matters, stay.
Yes, properly. It has been reflected. Now it's not.
In case I will insist for 2 minutes hearing. Lordship may insist.
No, I will not.
Yes, I'll insist for 2 minutes hearing.
Let it come.
I'll just interject, Lord, in that batch case 22817 of 2022. Lordship may just grant me some protection till Wednesday.
I will.
All right, no coercive steps till then.
Yes.
In my matter also.
In my matter.
22817.
Both these matters, 22817.
817.
New matter.
In my matter.
Greatly obliged.
All right.